Where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Good morning, everybody. Happy Wednesday. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. Sorry that we are running behind. I was talking Sleuthie's ear off, so that is my fault. I apologize. We started in court late anyway, so I know that we're it's already started, but it's not, we're not that far behind. And Sleuthie is looking for.
I found them.
Sleuthie was looking. Okay, Sleuthie found the docs from this morning, but then I realized as I was talking her ear off that holy shit, I need to go finish getting ready to leave because I actually don't get to sit here right now. So I will be back. You guys have fun. I will be listening on my phone.
Okie dokie. Hurry back. Be careful.
Yes, ma'am.
Okay, so these filings, hold on. So one, I see two. One is a motion to preclude the attempted use of any information not produced in violation of Rule 14. Okay, this is Hank Brennan filed this. He said, both the Commonwealth and defense are bound by Rule 14 obligations. During the course of this trial, notably during Shannon Burgess's testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. What a whiny little bitch. The effort of providing documents as a witness is being confronted with documents is improper. Tell me, listen, I didn't read that wrong. It says the effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objections, unnecessary sidebars, and a waste of time for the jury. I don't remember too many objections and sidebars, to be honest. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony. Okay. Then he filed a trial memorandum on expert opinions. The Commonwealth intends on asking Dr. Welcher, based on his review of all evidence analyzed and reviewed, a number of opinions, including but not limited to, number one, whether his opinion of whether the lacerations on John O'Keefe's, why are we calling these things on his forearm lacerations now when we avoided the word laceration for years? Now all of a sudden it's a fucking they're lacerations. Whether his opinion of whether the lacerations on John O'Keefe's right forearm and arm are consistent with contact with the Lexus right rear taillight. Number two, whether his opinion is that the Lexus collided in a clipping or sideswipe manner with John O'Keefe. And three, whether the collision occurred at substantially the same time as the reverse maneuver, which he identified from the Lexus trigger event 1162-2. Expert testimony on matters within the expert's field of expertise is admissible, even if the expert's opinion touches on the ultimate issues that the jury must decide. I'm skipping the citations. A question which calls for an opinion which is in the domain of the expert's professional knowledge is not necessarily to be excluded merely because the conclusion of the witness reaches or approaches the ultimate issue before the jury. The only limitation is that the subject matter discussed be within the witness's field of expertise and that the witness not directly, which is underlined and italicized, express his views on the defendant's guilt. Oh, this is fucking hilarious. It says, the only limitation is that the subject matter discussed be within the witness's field of expertise and that the witness not directly express his views on the defendant's guilt. And then in parentheses, a general expression of an opinion of guilt followed by a recital of all the evidence against the defendant is not permitted. Did Welcher or did he not do that literally yesterday when he started bringing up the DNA, Miss Reed's statements and interviews? Asking my advisor, I can't with it. Okay. Next page. Expert was permitted, this is in a previous case, expert was permitted to testify that anger, sadness, and rage, not mental illness, motivated the defendant's actions. Such testimony was not an opinion as to whether the defendant was criminally responsible. The Commonwealth is not asking Dr. Welcher to provide his opinion whether the defendant was under the influence, negligent, reckless, or had malice. The Commonwealth's expected opinions are admissible because they are within Dr. Welcher's field of expertise, based on the evidence he relied on, and they are not directly expressing or opining on the defendant's guilt. Additionally, but separately, these opinions directly rebut what was said by defense counsel repeatedly, that there was no collision. The scientific evidence, specifically Dr. Welcher's opinions, directly refutes defense counsel's opening statement. For example, so ridiculous. The defense asserted that, quote, the evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. Similarly, John O'Keefe did not die from being hit by a vehicle, period. Because at the end of the day, folks, there was no collision with John O'Keefe. You will learn, this is him quoting basically, I'm still in quotes, okay? You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car, not one. Further, nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV, not a bruise. Dr. LaPosada will tell you with medical certainty. Oh, this dumbass motherfucker wrote the same sentence twice. Dr. LaPosada will tell you with medical certainty, and in fact, John was not struck by a vehicle. He then writes that exact sentence again. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. Folks, the science will not lie. The physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. Now we're at the end quote. He basically did quote the whole thing. The defense cited Commonwealth v. Coleman without providing a copy of the case or a summary. Citing a case name does not make the case relevant or applicable. In Coleman, the medical examiner testified that in his opinion, the cause of death was homicide. The court referenced Commonwealth v. Lannon, opining the better course was to exclude such opinion testimony, but here it was innocuous. In the Lannon case, accident was offered as a defense and homicide could be taken to contradict that defense theory. Here, homicide does not seem to have such a contradictory implication. I would like to see him try to read this. He shouldn't write nothing he can't read. As to the defense theory of self-defense, i.e. justifiable homicide. In Lannon, the medical examiner went into detail about the autopsy procedure he had followed to reach the conclusion of death by gunshot wound of the chest, massive hemorrhage, and homicide, and the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired as opposed to the results of the shot. Happy birthday to whoever's birthday it is. I didn't see. Based on the data, physical evidence, and expertise of Dr. Welcher, it is his opinion to a reasonable degree of scientific and engineering certainty that there was a collision between the defendant's SUV and John O'Keefe that occurred around the time of the defendant's backing maneuver in front of 34 Fairview Road on January 29th, 2022. Okay. So that's all the things. So, let me share my screen. I'm going to be pissed if I share and we go on sidebar. Add to stage. There we go. I can't even talk about the filing. He's so stupid. I just can't. I don't have the patience for it. All right, are we in HD? We are normal. Oh, by the way, we're waiting for her opinion. Remember from yesterday.
All right. Good morning, everybody. All right, so
I'm going to give Hank everything he wants. Okay? Bring in the jury.
Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied.
Is it?
In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus.
What?
Because this opinion is based upon, among other things, his experimental work.
Oh, stop it. Beverly.
It came into evidence without objection as to scientific methodology and application.
That's because we want to ask him in front of the
However,
jury.
he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology.
What about sideswiped? Can he say that she was in a sideswipe collision? How about that one?
The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
Cool beans.
All right, so the jurors are lining up. We should have them momentarily. Why don't we bring him in if he...
Wait, how are we this far behind? Oh, it's only a minute. Okay. Wait, what?
The updated version we provided a copy.
Come again?
The updated version we provided a copy to the defense with all the redactions.
Okay.
The
Are you in agreement with this, Mr. Alessi?
I haven't gone through, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I just go with
Yeah, you do. Hank's a snake.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude.
You know what I would be doing? Every day, if I were the defense team, I would be inching my table ever so closely where no one would notice. And I'd keep scooting it forward so that one day this jackass sits down, and when he goes to stand back up and push his chair out, he bumps the whole table and embarrasses himself.
And that is in that version. I didn't want to pull it out with the court's order, but I'll.
Bev, just laugh at
Do
me.
you know the number? You don't have to find it if you don't.
It's 131.
Oh, was
Who's
it
that?
130? Was it 131 yesterday too?
It was.
What's that?
So at sidebar, I said we could go back to that. Mr. Lessie agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Lessie. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your honor's recollection is correct.
Yeah,
I'm okay with the heading removed.
And we were going to start on that, but you thought because I struck it based on the objection, but then at sidebar, I said we could go back to that. That's your understanding
That's
too.
correct, Your Honor.
And I'm sure that Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
Like my ADHD is making me ill. Like this, all of this, all of this, all this, all this shit up here, all this, these boxes of whatever, this, whatever, this, like there's too much going, this, why is there this little thing here? Why is there so much here in this tiny little space? Oh, I'd be claustrophobic. No, I can't do it. This needs cleaned up immediately. Lally, get on it, Lally. Clean it up.
I think he did as well.
I did.
Thank you very much.
Okay.
Oh, anxiety inducing. Look at it all. Oh, Beth laughed at me
Are
again.
they out there?
Oh,
Paul?
you're right,
Okay,
right.
thank you.
A trash can. Someone's going to trip on that trash can.
Draw near, give your attendance.
Oh, there you go.
Yay. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard.
He said cunty.
Commonwealth of Massachusetts, court is now open. You may be seated.
He said the
All right,
cunty.
good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yeah, sure.
Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor. Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113.
Are we going to ask him why he felt it at all necessary to dress up like John O'Keefe for this experiment?
114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
That's it?
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide
That's literally insane because he specifically was trying to recreate the exact wounds on John O'Keefe and was conscious and aware of his body positioning, which John O'Keefe would not have been.
130, please. What? Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Sure. Thank you, Mr. Brennan.
We're going to move forward.
That was an accident.
Yesterday, when we left off, I had asked you,
So we need to take this slide down.
Sorry,
you could take the PowerPoint down, please.
that was in a different spot on the slide. Hold on a second.
Good grief.
Right, that's better.
Thank you. So I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption.
Is it cross already, too?
Something or not?
Looks like he's counting on his fingers. Are you reading from something?
no, I am counting on my finger.
Okay, thank you.
So, I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height,
Teresa, stop
the
cheating.
type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
Okay, what about the damage to the taillight?
In addition to the text stream data you consider, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty
Lord, I can't.
in whether
Why does that sound like nails on a chalkboard to me? Every time he says that. Degree of engineering certainty. Makes my eye twitch.
damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.
So there's been two.
Wait, I just want to address this real quick. Nania said, and there's the fact that a parked Lexus sits 2 inches lower than a moving one. Hopefully Alessia asked about that. Is it the same as, so like I once had a really nice Jeep and the little thingy in the center console had like a little knobby knob where you could put different mud, rocks, road, whatever, like there were different things, and based on that it would adjust the height of the Jeep. Is that kind of what we're talking about? And what would happen is when you get in the car, turn the car on, it would go back up to the adjusted height, and then when you turn the car off, it would go down. You could also set it as preferences. So like similar to how you set up, like you could program a driver into the driver's seat. And when you get in and start the car, whatever driver it's set on, it will move the seat like forwards or backwards or whatever to wherever position. I think the chat's behind. I'm going to press play and then 10 messages are going to come through.
Potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was
Bitch. Okay, so for anybody that doesn't know, that's Arca's thing. So hold on, I'm going to rewind.
an impact. Two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion?
What sciencey stuff did you use to come to that conclusion? If it's more than 8 miles per hour. So does that mean throwing a glass would also break the taillight end? Because we can definitely throw faster than 8 miles per hour.
Opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent
But you said yesterday that you don't even know what the speed was when it impacted him.
with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
Yeah, objection. Like, how would he know if on January 29th, 2022 at 12:30 in the morning that the ground at 34 Fairview was frozen?
I'm going to allow that.
Oh,
Yes, it does.
Yes, it does. You fucker. He's trash. Come on, Alessi.
To finish, I'd like to ask you a few more questions.
I wish you wouldn't.
You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate.
Is this man about to give us examples that include two cars getting into a side swipe collision? He understands he's implying that John was in a side swipe clipping collision with a car, right? We're not talking about two cars.
And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer,
Love you, Kim. Good
meaning
morning.
the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going
Okay, what about a
because
person
you
though,
don't
sir?
have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
Okay.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
Yeah.
It's the same thing. So
What?
when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping, or
Okay. I don't disagree with that. But you have failed to say why if the thought is that his forearm, that's what you're saying, is the forearm is what clipped the vehicle or whatever, he hit the tail light with his forearm or whatever. Explain to me how his arm, his elbow was not broken or bruised.
glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures.
Sure.
Depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian
Okay, but you're saying that the arm came in direct contact with a vehicle going over 23 miles per hour.
accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
Okay, list them right
I'd
now.
ask you to turn to slide 139, please.
List them because I'm going to read them. Exactly who this. So 2 reasons I say exactly who this. This one was what I was responding to, but then I saw the one above it. If John was trashed, then he likely wouldn't tense up when getting hit, which would mean less injuries. And that's true. Haven't you ever heard about like alcoholics, people that are drunk in drunk driving accidents? They somehow miraculously don't get hurt like other people do. That's why, because they don't tense up. And then the other one was it takes minimal pounds of pressure to break an arm, which I also agree with.
Oh, sorry.
Yeah, exactly.
I fixed those other 2 slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a
Fuckery.
trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Well, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit.
AOR area. of rest.
AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Yeah, we didn't really have that. So
Next slide, please. And what does this represent?
I was gonna say, tell me exactly what part of this person's body made impact with this vehicle.
So this is the decedent in the case, the person that
They also very clearly have way more injuries than John O'Keefe. Broke ribs, blood in his lungs, lacerated his liver, wound on his right upper arm, and then multiple abrasions everywhere. I'm not sure where we're going with this. The speed was like 25 to 35 miles an hour, I believe.
hair.
Yeah, 20,
So this
25 to 35 miles per hour.
is the decedent in the case, the person that was hit.
Poor feller, I feel bad.
He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes,
Please,
sure.
do you want that expanded like other times?
Are we going to ignore that his liver was lacerated and he had blood in his lungs?
No, my pleasure, Your Honor. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib.
Yeah.
And a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, They're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
But even if he was, if obviously wasn't hitting the arm like you are claiming John was, like, let's say he was hit exactly like he's saying that John was hit, then they'd be pushed into his body. You'd think that would break his ribs. I don't know. I don't think it's, I don't think that's the same. I think they put that poor man's body just out there for everybody to look at for no reason. To prove that John wouldn't have broken his arm. But he had all those bruises and shit. John didn't even have a fucking bruise on his arm. So again, it's still not the same.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
But what about his arm?
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move into evidence subject to redactions.
Yeah, I'm sure it
Dr.
was
Welcher's
your
PowerPoint
pleasure.
presentation.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor, thank you.
From what I understood about what he testified to about his experience, it doesn't seem he's ever come head to head with a paid defense attorney, like a private paid defense attorney.
In both the flash drive and the notebook.
On representation, it's consistent with it, it's the same as that item.
So let's put them both together now and decide later, okay?
Those two slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that was-
Thank you.
What's incorrect about them?
What exhibit number is it? Oh. 206, thank you.
Exhibits 206 A and B.
All right, Mr. Alessi, whenever you are ready.
Oh, he'd been fucking ready. He was ready last night.
Sure.
Who are you?
Morning, Dr. Welcher.
Live footage
Good
of
morning.
Alessi.
We haven't been formally introduced. Your whole name?
Robert Alessi.
The fuck? What? She's like, oh, you stupid little bitch.
Sir.
We haven't.
Weirdo.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice.
I'm about to fucking just destroy you.
To meet you.
He's like, oh, you silly bastard.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct?
Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics.
Forensics is? I don't think so. Okay, I can already tell that we're going to be super combative and defensive, and I'm so here for it.
It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
yeah.
yes, certainly.
We're not smarter than Babalesi. Sorry.
For the court of law,
It
yes.
ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So
Yeah.
it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information, truth sometimes, again, can be subjective.
Sir.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
Yeah,
in terms of your role as a biomechanical engineer and accident reconstructionist,
Sure does.
is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony
Anybody else feel giddy?
and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem,
Yeah.
the collection of data through observation and experimentation,
Mhm.
analysis of the data,
Mhm.
the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed
Oh, Lord.
and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical
Is he going to answer a single fucking question just with a simple answer?
analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to
Oh,
submit
Lord.
my analysis for peer review. So
What
this,
about your fucking coworkers, you moron?
the forensic analysis in court generally never goes under a peer review process. The methodologies underneath it and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking
Right.
about your methodology,
Mhm.
your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no
Oh
way
my
of
God.
publishing this analysis.
I'm
So
sorry, sir, to
get
interrupt
peer,
you.
I need to,
Go ahead and answer your question.
you're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is.
Can you
So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is
Mhm.
not your analysis here in this case.
Oh.
My question
Oh.
regards the methodology that you use here.
Right.
Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Jesus Christ.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
Right.
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly,
The answer-
exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, this is, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert.
my
I
God.
think
Why
I would
did you
generally
say-
agree with
why did
it,
you
but
sit
I
there
don't want
looking
to
like
step out of my.
Bro, I
So
just wanted,
let's rewind just a hot minute when Alessi's talking.
I just want him to answer one fucking question. Just
We
one.
won't. Well, hold,
Elaine,
no, go back just a tiny
Engineers
bit.
doing studies,
Pause it.
medical analyses, it applies to doctors doing studies.
He does this whole thing with his mouth. What is he? Why does he do that?
Because he's getting ready to answer before he's even done speaking, yet then beats around the bush the whole answer. That's him getting ready to talk before the
Oh,
answer.
so he keeps going with his mouth so he can be ready to say whatever he wants to say.
Correct. Yes.
Oh.
Watch.
Engineers doing studies and other scientists doing studies.
so I'm not.
See, he was already ready to answer.
Huh.
hmm
Cognitive expert. I think I would generally agree with.
Why has he got that pen clipped to his finger like a child? Is it like a stress thing? Like,
Maybe. He's like, cause pain somewhere else. I won't feel it in my chest.
yeah.
Cause pain somewhere else.
Look at it.
with
Stupid.
it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias if you
Fair.
like.
Let's talk about confirmation bias. Now,
Cognitive-
confirmation bias is,
What?
This is cognitive means using your brain, your knowledge and understanding. He's not cognitive. He just like, I'm just not an expert in that at all. Background: Alessi filed a motion in limine to exclude
yeah.
Dr. Walter because his methodology wasn't tethered to scientific studies or
Correct.
something like that. Alessi is going after him on this right now. 100.
Yeah, that was we won't spoil it for the rest of the family, but there was a filing for people that haven't seen it. Actually, I want to say there was a filing, it was denied, and then they did a motion to reconsider it as well.
Yes.
actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the
But
term
would you like to avoid it?
failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data.
Oh my
You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking.
How do you come up with your different experiments if you're not asking the question, how did this happen?
Well, I think that the issue is he starts at the final point and then does all these experiments. I mean, he's 100% confirmation bias. That's why you see him leaning into the car.
Yeah.
Which is not scientific, which is why we were all talking shit about him yesterday.
I mean, there's a reason.
Show me how, like, just take the Lexus, take your body, and show me how it was hit. Like, that's it.
There's a reason he didn't use a dummy and like hit it going actually 24 miles per hour in reverse. You know what I mean?
Yep.
Like, he used his own body and then only went 2 miles per hour.
Well, what, he didn't go anything. He just walked into it.
Unless he just basically said, "Oh,
I clicked the same."
Oh my God, Teresa!
Sorry.
I don't think you're understanding or using your cognitive skills for my question.
Yeah. So what you're telling me is you don't understand cognitive skills. Oh wait, you did say that you have no clue what cognitive means.
Basically. I'm ready to see him go, but I'm also ready for the trashing that's about to happen.
God, I can't wait.
I'm like giddy for
So
it.
tired
About
of this guy,
the
though.
method or
He's like
the
a fucking
process.
rat.
Well, and he's dragging this on because he's answering these like, surely the jury's going to notice that like the way he's answering these questions is bizarre, like compared to how he was talking to Brennan and answering those questions.
Mm-hmm.
I mean, he literally won't concede to any question that he's actually being asked, even if that means he has to take a 10-minute side journey to say the exact same thing. It's like, it has to be in his words and not the defense, because he doesn't want the jury to think the defense is right about anything they're asking.
Lacey, they have a witness list of about 40 people, and they wanted to add another 4 to it yesterday, which I don't know what her ruling on that even was.
I do have a list. I'll put it in the chat.
And yeah, I mean, now will they only call ARCA? So last year they only called 5 witnesses total?
Yeah.
4, 5. They called Lucky,
Dr. Russell. Oh no, they
Dr.
called
Russell.
Dr. Russell, the other doctor,
and the
2 people
2.
from ARCA.
That's it. That's how they ended. So we have no idea who they're going to call outside of ARCA, but yeah, they have a big ass list.
So here's the link to the spreadsheet. Just go to the witness lists tab. We'll be here until Thanksgiving. No, they don't have to call all the people. All right, I have to pay.
And
original estimate there would be an 8-week. I think this is going to be much longer than before.
you think so? Oh, the defense is going to be much longer.
Yeah.
Well, I mean, I don't know. Yeah, depending on how they feel that they did here on direct, they may just call the specific ones that are going to talk shit about these fuckers and go, that's all we need. And you just don't know. You have no idea what their strategy is. Are they going to call a Proctor? Are they going to call a Tully? Albert, McAlbert? Mav, the Commonwealth's doggy person is for rebuttal. They can't call Turtle Boy. He was booted from the list. There was no Bev said no reason for him to even be on the witness list.
Yeah. But like, I think ARCA this time around is going to have more information. I hope we're going to have like diagrams and
well, yeah, now they actually did a totally different reconstruction, and they have the ability to actually speak freely because now they are hired by the defense versus by the DOJ.
Right.
They call Proctor. Not screen. Free Cora.
Who wasn't crossed out?
Turtle Boy. He's not crossed out on your list thingy, maybe, or on the other list.
Oh, well, that's just because he didn't get called. Like, I haven't crossed out anybody that's not been called. It's
But
only
she
people that have-
removed him from the witness list.
Did she?
No, I'm almost positive she did. If I'm
No,
wrong, I'm wrong. She said no. He was not a witness. What did she say? He was not.
He had a reason, like he had a good reason, a legitimate reason for pleading the fifth, and
Yeah, she made it so like he can't be called.
oh,
So I'm almost positive she removed him from the list.
oh shit. Well, I can remove them, but I think we all know
It
he's not.
doesn't matter. It's irrelevant at this point.
I just like to, you know what? No, I'm not going to, because I want to get an idea of who they actually did call versus what they put down. Like, when you look at it this way, seeing that they didn't call any of the Alberts or McCabe's, didn't call the driver of the truck that pulled up behind Karen Reed's vehicle that night, didn't call the IT guy for the town of Canton, so we don't have any like
No library.
surveillance of her car going to or from. I honestly like having it here to see who we have put on here. Like, I still have Karen Reed's lawyers here because of the audacity he had to put them on his list.
So stupid.
Yeah.
Did you go pee?
Wait a minute. Am I tripping? Did he? No, I did not go pee. I do have to, though. Did he not call Justin Rice, the one that pronounced John dead in the emergency room? I don't have him crossed off.
Not call him.
What?
Yeah, no. We haven't heard from Dr. Rice.
So weird.
Hold on.
And then he wanted to bring the Sullivan sisters in, and he didn't. But I think he had the niece end up talking about some of that. I look like the Grinch when I say it, with the hand movements and everything. All right, I'm gonna push play.
I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypothesis.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question to make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mhm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mhm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Fucking. He's like gonna argue just to argue. Sir,
And
unless he is smarter than you.
once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that most out of all of them, it's a relative thing, the one that most consistently
I need to take notes.
produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts
funny,
State
apparently.
Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, Paul?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
Trooper Dumbass has entered the chat.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Correct.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea.
That's a lot of money for a whole lot of nothing.
Well, for the
Accepted.
fact that they already, that the Commonwealth already had this quote unquote done by
Right.
Trooper Paul. So why
Right.
spend any money to do it again? Much less
Well-
$44,000.
They also need to factor in the money to buy the car,
Mm-hmm.
but I guess it's money well spent to them if it means that these people are just going to get on and say what you want, what they want, what you want them to say. You know what I mean?
Yep.
And I think that's evidenced by the fact that he is unwilling to even let a question be asked without clarifying so that it doesn't like favor Karen Reed or possibly go against something that he did. If that makes sense.
Yeah.
I know what I'm thinking in my head, but I don't think I'm saying that exactly right. Like the reason he won't answer a direct question is because he doesn't want it to favor the defense in any way. So he has to like reword the question and then give his own answer.
I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would,
engineering company. We bill for our time.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
So how
Well, you're
exactly
not
are you
just
independent?
billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir,
Are you getting
you
paid?
are a senior vice president of Aperture,
Yeah.
are you not?
I am.
Yeah,
You would
Exactly.
know, wouldn't you, if your firm was not getting paid
exactly.
for work since September 23rd of 2024? Wouldn't
Exactly.
you?
No, probably not.
Why?
Usually it takes, 9, 10, 12 months
Oh,
of not getting paid
bullshit.
before the accounting department reaches out to me.
Oh, come
What?
on.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or
2.5
12
years?
months, if you weren't getting
Misspoke.
paid, you would have been notified by that by now, correct?
He's been on that. for 2.5
According
years.
to your own answer you just gave.
No, he missed.
I've not been on this case for 2.5 years.
Yeah, that's wrong.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's
Did he do that
what?
on purpose?
less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill.
Pause it.
You,
Did he
as
do
you-
that on purpose?
I don't think so.
You think he just made a mistake?
Yes.
What? Why? Where would he get 2.5 years?
Because he was just talking about how he didn't get hired until 2.5 years after the incident. So he misspoke.
Okay.
But when Welcher answered, when he said, you're the senior vice president, are you telling me you wouldn't know if a client wasn't paying you? And he specifically said it would be 9, 10, 12 months before the billing department would come to me. No, sir. There is no way in hell that your company is going to allow someone to go that long without paying and not make you aware. But he did that on purpose because he was trying as quickly as he could to count out from now until like when he was hired to now. I mean, he's a trash bag. He's just a trash bag.
Well, yeah.
sit here today do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign. So I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that
You don't know if they paid
contract
you?
obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it,
Right.
correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
I want him to explain why he thinks he's independent. That's what I want to know.
Also, you testified on direct that there was a purchase of a Lexus exemplar
Mm-hmm.
for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture.
What?
And is that then
Reimbursed.
cost passed on to the Commonwealth?
No.
What?
So
Wow.
you pay for the Lexus, you don't.
This little bastard is going to tell us that Aperture came out of pocket to buy that brand new SUV that they could only use for her thing.
Well, how can he say that?
You're
it's-
lying.
Well, how can he say that it's not billed if he has nothing to do with the accounting?
Yeah, that's true too. But that's just like terrible business. Why would you do that? So you've been paid $44,000 so far, and you spent $80,000 on a car. So you haven't been paid for anything. You're in the negative.
Yeah, I don't believe that to be true.
No, you sound so stupid.
Well, I also
Has
think
that
that
cost?
Aperture itself was probably very excited that they were going to get so much, grand exposure from being part of the Karen Reed case and how it was going to, boost the business.
Well, that's backfired, I would say. I would say that has backfired.
Correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir.
Exactly.
So
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
So you did testing on this vehicle. Is that why you were so ginger with it? And you didn't want to like see what it would take to break the taillight because you intend to sell it?
Yep.
Huh.
yeah, I don't want to speculate. I just wanted to see what the obligation was. So
The obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000
What?
to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
That is
So the Commonwealth is,
that's more money. Like I'm trying to think off the top of my head because I'm so shocked. But like I don't even think Hank Brennan has made that much. That plus the 44,000 they've already gotten. What? To review other people's stuff? That what?
obligated
Oh my
to
God.
pay at least $325,000. And is that correct?
What?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
Wow.
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of
Right.
2024, when we were talking about dates, you
Right.
said that was about 6 months that your
Correct.
firm's been retained. Did I
He hasn't
have
been
your
retained.
answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so
Okay.
8 months. So for 8 months of work,
And not nonstop every day.
about $400,000. Is that correct?
Wow.
So there's 3 offices working on
Wow.
the case. There's the Boston office,
No one cares.
there's Mr. Burgess's office, and there's my office in Long Beach.
The answer is
I
simple.
only know
My God, he's
about
right
the
by
billing
me.
from my office.
But you signed the contract on
Exactly.
behalf of all of Aperture,
Correct.
not just your office, correct?
Yes.
That I don't know, but I definitely did sign a contract.
So then what are you suggesting that 300 or $400,000 is only for your office and that the other offices are making money too? Like, what are you even trying to say?
Oh my God.
You are the senior vice president. That means of all the offices, and you signed the contract.
$400,000
Money.
for 8 months of work.
And that's
For
not
a,
40
for a
hours a week.
job that was already done by
Done.
Trooper Paul, somebody
Exactly.
who they paid $100,000 to for a year and with salary and got exactly what he would normally get whether he did this job or not.
Yep.
Oh my! And then he's gonna say he has no bias
Uh-huh.
and was not in it to.
He's independent. I want to know what that means when he says it. Like he said he was an independent person. He has no skin in the game. What does independent mean? What part of everything we just discussed means you're independent?
$400,000.
That's a lot of money, Teresa.
That is a lot of fucking money.
Mm.
Would it refresh your recollection as to who you signed the contract on behalf of whether it's all of Aperture in all offices, if I showed you the contract?
Show it.
Sure.
May I put you on it?
Yes.
Of course it is.
May I put you on it?
Yes.
Thank you. Sir,
I mean-
may I speak, Your Honor?
Yeah, could you direct me so we're not wasting time?
Well, it's what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
So let's just say he says, no, it wasn't on behalf of the other offices. Okay, so then that means they're paying you even more money. That's not better.
You think he got a pay cut after now he only has an
When he's
associate's
done,
degree?
Mr. Lessie, you can take it back to the podium.
Yes, Your Honor. Thank you.
I just want to see $400,000 worth of work. My God. And you got a 200-page slideshow?
Can I have a few more questions before I do that, Your Honor, for foundation purposes?
You see Withal's comment?
No, I can't read.
Who would you like me to start with?
So-
Does this fuck company? Have you guys
Go
seen
ahead and start with your.
ties
Go
of
back to the
Mary
podium.
Hollis? No.
I haven't seen any of that either. Now I'm curious
Oh,
though.
yeah.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So
Oh my
it
God.
lists the legal address as my office. So for my office, yes.
What?
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to
So are
disbelieve
you
that.
saying there's contracts with other offices?
And
don't know
is
about?
there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
Oh my God, we're like not even.
Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct.
Good grief.
And that is my signature on it.
Right.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct. That you didn't
Independent.
have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics,
Okay.
you submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
Mhm.
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
After
I
trial
still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Take it all from him.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank you,
please.
She just made him shut it down. Sometimes I feel like Alessi does that on purpose. I'm not gonna lie. Like, I feel like he's like, I don't even need him to actually look at that, but just to piss off Bev, I'm gonna like ask if he can look at it so he can turn it back on.
Alessi's last ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my
Yes,
direct
sir.
testimony.
If you can just hear my question, it's
The
this.
date, sir, just the date.
The
Yeah, this
version
updated one.
of the
When did you make that?
presentation
My
that
God.
you put on the screen.
Mhm.
When did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the
Perfect.
version before
Yeah.
that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my
You just said
question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question.
God, this fucking
Your
guy.
first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Right, so you created on January 30th, 2025, you made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yes.
January 30th, modified May 13th.
Right, if I could finish my question, and I might be able to shortcut this, thank you. So you created the original one on January 30th, 2025, you made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Mm-hmm.
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to
Objection.
what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138. And then I was told that the defense was having problems with my PowerPoint. So I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I
So
want to
you're
go to the
offended.
first half, sir.
So
Sure.
why did you have?
And
Why
I'm going
did you
to
have
try
to
to
add it
shortcut
if
this.
you'd already
And if
done
I'm
it?
not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path,
P-A-T-H?
correct. The path Miss Reed was driving.
Right. The what you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
I could smack him.
Did you consider that change significant?
No,
Well, then why did you make
Why add
it in the middle of trial
Because
if
the
it wasn't
defense had a
significant?
problem.
Why didn't you just leave it off and then discuss it in terms of testimony?
so A, it ultimately was left off. B, because it was insignificant and I
Why'd you
didn't
add
need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Miss Reed. Is that correct?
I believe that, yes, that is correct.
Where'd you observe
Do you
that?
know that clip has been in existence for months?
I don't believe I got it until April.
Got it.
But it was public.
So a clip
Wait.
that has been assumed.
What did he get in April?
You got
And
the
when?
clip.
Did he see it on trial, in the trial?
The clip's been in existence for months. You just got
Hold
the
on,
clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be
Look at your
helpful.
shit. Somebody get up here and take all his shit away from him. Get it out of the box there. Throw it in the trash. Get all this clutter. Clean it up now.
Oh my gosh, he has to look at all of his shit. He can't remember shit.
Everybody's grounded. Clean it up.
Close your
Yeah,
computer
let me
and-
close it. Sorry.
You already
trying to
told
answer
to
his
close it,
question.
bitch. You were told to close that computer too.
So I'm
You're
going to
in
ask you to
contempt.
close the top.
Yeah, that's probably a good idea.
Just flat.
Yeah, she already told you to
Thank
do
you, Your
that.
Honor.
God damn.
So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
When?
What was tell me the
Were
circumstances
you watching the trial?
by which you got the clip. Did you ask for it?
I was told there was a new interview.
Oh,
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
oh.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly.
Huh.
So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Oh, when the trial
Mid-April.
started.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
During trial.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were
Oh, you got it for the
aware
defense?
of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending
Who dis? We're about 45 minutes, so that should be good to get us through like lunch when it comes.
to submit that May 8th report to the Commonwealth?
Yes, we'd had a discussion before that he had found new information that changed the timing.
Oh, he had found
Oh,
new
dear.
information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
Objection to the question.
Of course.
To allow the question, but you have to ask it differently. Mr.
I will, Your
President.
Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Well, he
Did
told
you
us
ask
he
him?
was there.
What do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that
I was hoping he was going to say, did he also tell you he was currently pursuing a bachelor's?
information
is new as opposed to
it's always
Did you take him for his word?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was.
Which is kind of crazy considering he wanted all his own data, right? He went and like downloaded all the whatever, the text stream stuff, so he would have his own thing. So he would know it was like done right, but yet takes Burgess's word for the things that he said.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's
Oh
new,
my.
old, I don't care. It's not relevant to what I'm doing.
Why,
I don't
how's
say this is
in
new
the
data, this is old data. I just care what the data is.
There is rules here, sir.
There's no data. It was Karen's statement.
Has
Right.
Aperture ever submitted a report, a changed report in the middle of a trial for your knowledge?
I have no idea.
Sorry, hold on.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of the trial?
So Aperture is like 290 people. I can only speak for myself.
That's really not that big of a company.
No, it's really not.
I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then?
Sir, you're the senior vice president of Aperture.
You better be able to speak for a lot of fucking people. Otherwise, you
Yeah,
had the
like
wrong job.
For yourself, recall any instance where you submitted an amended report in the middle of a
Resume
trial?
drift.
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess again? Dr. Welch, you can file out behind.
Great.
Rest of the jury.
Love to do the rest.
I'm going to ask you to take lunch break. I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break,
Thank you.
okay?
Did Liza cut her hair different? Why is it
Yes,
different?
and I'm not a fan.
What is it, bangs?
It's weird bangs too, because she's got the
Oh.
wave. So she's
Yeah,
got.
I'm
and
not
then
a fan.
yeah, me either.
I mean, I'm
But
a
she's
fan of her, and
Yeah.
entirely a fan of her, but I do not like that.
Yeah, and she tucks that hair behind her ear, so then it gets the ear curl.
It is mulletish.
Yeah, I'm not a fan.
She's so beautiful, though. I mean, it'll grow out. But bangs, I had bangs once. They irritated the shit out of me. I had to cut them like every
Yeah.
week, otherwise they were in my eyeballs. So but-
I had bangs since I was a kid.
I know they're
Micro
trending,
bangs, they're
but I just
trending.
think I
Ugh.
liked her other hair better.
Yeah, get that back.
Like, and I know people don't like his beard. I don't
I like beard.
dislike it. I think it makes him look more like normal.
I like a beard. Tickles.
Oh, Teresa. We didn't need to know that. Damn
May I,
it.
Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And
Naughty, naughty.
in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes.
Yes, this is the day after Memorial Day, sir.
Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up, and it was some internet troll.
Sure. I'm asking about emails.
Oh, that's fucking awesome.
From the prosecution.
Oh, No, there's been no emails about what's been going. I mean, been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Oh, you're not?
asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that?
What he should say essentially is if you're looking at data for a key cycle that is a different trip, doesn't that make this data irrelevant? Isn't it important that the key cycle be the correct one, the one where we say that John was hit by a car?
Mm-hmm.
Otherwise, the data is irrelevant to this.
With a totality of what? Yeah, and anything, there's nothing else to be totality of.
It's irrelevant to this, why we're here. If it's a completely unrelated key cycle.
Just a matter of logic, sir.
Yes, logic.
So again, the text stream event tells you the trip and it tells you the time. If you're saying
but it doesn't tell you the
No, it
trip.
does not. Yeah, it doesn't.
You determine the trip. You have to
Yeah,
make sure.
it doesn't tell you the time.
Exactly.
associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle,
I hope we're going with it.
then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Oh my God.
Is he purposely doing this?
I think like unless he's going to Jackson and being like, this guy's a fucking moron. I can't even ask him a question because he's a fucking idiot.
He literally needs to say, what is the importance of that key cycle and the event recorded in the key cycle to being the key cycle where she's driving from the waterfall to 34 Fairview? How important is that to be the correct key cycle?
He's going to have to break it down really dumb.
Let me try it a different way.
Oh, for crying out loud.
Good luck,
Your
sir.
analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Real world
Again,
event.
you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are,
can you zoom in on the key cycle?
oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right.
Yeah.
So you are aware that the Commonwealth had maintained up into your firm's engagement that
Are you saying there's no basis for the question? All right, I'm going to allow the question and.
Hank, shut the fuck up.
you are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis.
No.
As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of
correct?
course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
Great, now I got the hiccups.
This dude's giving me a headache.
Oh, I pre-medicated.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Leslie, the court report.
How annoying.
Thank you. I will.
I'll object again to the question that's coming.
Brennan just said, I'll object again
Can
for
I-
the question that's coming.
Again, my question?
Ask a,
You gotta wait, Brennan.
it's an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
Of course you will.
I'm not giving the instruction now.
Why can he not ask?
Dr. Welcher,
He looks amused.
in terms of the analyses that you have reviewed in this case,
Marco.
is there one time that you understand
You know he does.
there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry.
Bro, Hank is so exhausting.
Oh yeah, he doesn't want the jury to know that the Commonwealth has changed the time like 4 times because they don't actually have any fucking idea what happened.
Yeah.
But we're allowed to talk about the fact that he's getting information and changing his PowerPoint
Well,
and doing all these things, and that he's changed the time, that Hank has changed the time during the fucking trial, but he's
She's
not allowed
back.
to talk about it.
She's back.
Oh, she is back. Thomas,
That's
can you
John's
get your wife?
That's John's ex-girlfriend who he like went on a date with to the movies like 2 decades ago, and she's obsessed. She's here in court, back in
She
court.
thinks
She's
that
married.
John's like the love of her life.
Yeah,
But she's married.
married, but she's here.
Excuse me. May I, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later.
Brief.
As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is it is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right.
Oh my God.
And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you usually acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's.
I got the exhibits.
Oh, you did?
Yeah, I'm gonna start putting them in the Google Drive.
Sweet.
Often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the. That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old. Therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mm-hmm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200. Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair
Well,
enough.
that's what I
We'll
called
call
it.
a
You didn't
spoiler.
call it that yesterday.
You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen
You couldn't ask if you could look at the property?
cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes,
Then you know that there is a berm raised above street level, correct? If you did the scan.
correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler, you measured the height, you did all
Absolutely.
that?
Yep,
Where was it? It was you? Was it you in that slide?
it was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose
You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler, because you don't have information as you just described. Is this
Sure, it
correct?
could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
When you're leaning into the car.
I could probably find the slide for you.
So you didn't do a force
Yes, do that,
analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
They do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
So jurors, your lunch is here. We'll see you in 15 minutes.
Who's right for the jury?
Crap, we caught up.
Goodbye.
I'm putting these in right now. There's none that are that I can tell that are like within stuff.
You actually caught up, or like, or did you get into lunch?
I don't know. I don't know if she said we're going to lunch.
Well, they already had a morning break, so it would have to be lunch.
And I thought she said something about 15 minutes, but
Let me go back. Hey, Scully. Remember for a year? What? And yeah, see, Mama, like you've been a member forever. I hope did it give you back your status at least? I put a video in the back chat, in the private chat. If you want, like when, if we have a lull in time and want to play that. It's a good video from Be in Trouble.
I think we have time right now.
But if you want to go over your exhibits, we can do that though.
Well, no, I'm saving them now. None of them, like the shit we want. Like, oh,
Okay.
whose fingers are too fat? What?
Passengers'
Oh.
fingers are too fat. Off topic, last night I was watching crime docs on Max and decided to watch Devil in the Ozarks. And I get up this morning to the news that guy has escaped from prison. Like, when did he escape? He escaped yesterday? Well, that's crazy. My husband just said he saw something about an old guy escaping.
That's crazy. Like, how old is old?
How old is old Mike? Well, he thinks I'm old, so
Oh, for
60s he
God's
said.
Well, he's determined, it sounds like.
My husband or the guy?
The guy.
No.
Let me get my glasses. I can't see shit.
The Devil in the Ozarks guy. He escaped. Yeah, he's, oh, look, a bald white guy. I don't know, 50, 60? Where was he in prison? Hey, Kat. He was a former cop. Former police chief. He impersonated a guard and walked out.
Oh my God.
They're probably all a bunch of bald white guys.
Probably.
In Massachusetts? Arkansas. I was like, Massachusetts does have a bunch of bald white guys. It'd be easy for him to pass as a cop. Or guard.
So 9 minutes ago, Sue O'Connell said breaking for lunch. So we are in lunch. And we should play this. I mean, this is only 20 minutes.
Mass has no Ozarks. So the beginning of this video is just some of the data and stuff that Welcher was going through yesterday. And then he's got a couple commentary things on here. And then he kind of goes through, I'll let you watch it, but just so some of this is what we saw yesterday. And if you guys remember, Be in Trouble 31 is the channel that we had done like the reenactments. We've watched a bunch of the videos. Like they did the one with the jelly arm and broke everything, like broke all the bones. Like it's a great channel for information like this. So I thought this would be a good video for us to watch together.
Yeah, because I got like all of Brian Higgins's text messages and stuff, but none of these things yet. I only got, well, so far that I've seen, I only got exhibits 115 and 132. Those are Brian Higgins. And then I got 1, 2, 3, 6, 7, 8, 10, 11, 12B, 13, 16, 18, 19, 20, 24, 25, 26, 28. And that's all I see right now. But they're probably at lunch also, so.
Well, at least you got some.
It's better than nothing. I'm hoping that I'm like on the list now.
They'll boot you, just like Jody did. Yes,
I think
Joanna was in chat. He was in chat like last week, and I thank him very much for all the work that he's put in because it's very informative.
I'm way kinder to these people than I am to Jody.
Yeah, no, Jody deserves
He's
it.
an asshole.
I really need to get like new batteries for my mouse. It's really starting to piss me off, and it's my own fault because I don't go get new batteries. But then it just like won't do what I want it to do.
That's annoying.
I know. Which part? The fact that I don't get the batteries, or that it's bugging me?
Both. You can't really bitch about like it not. You can't really bitch about it bugging you when you choose not to go get the battery. I have a battery daddy, so like any size battery.
Oh, I bet you do. Is that what they call it nowadays?
Any size battery, like it has a spot, and I don't want for batteries ever. Teresa.
I fucking can't. Oh man, I love being friends with you. I just want you to know that.
I fall into these pits.
It's sometimes it's just you set me up so well. But at least he's all, I want a battery daddy.
Hold on.
Travis.
Hold on.
Right, T-Dub? Okay, go ahead. You can play. I'm gonna go get batteries.
Excuse me, but where? I cleaned out the. Oh, there. Okay. Very heavy. Make this big. All right. This. Are you ready? Oh my God, did you go get batteries? So you don't get to see this? Should I wait till she comes back? I'm going to wait so she can see this. But it is heavy. All right, let's watch this. Let's watch this show. Is the sound on? Okay.
My fingers are too fat.
Thank you.
Okay. So what you're looking at is what I call event 1162. If you see anything in blue on these charts, that's information that I added. I typically put my initial, JBW, Judson Blair Welcher, that's me.
Okay, he's trying to pass this off as Toyota TechStream. It is not Toyota TechStream. This is a Bosch code reader scanner that he had hooked up to the vehicle, pulled the data, and then he made this graph and put the information in himself. Toyota TechStream would have had mileage, it would have had time, date, and not only mileage, it would have had 1/10 of a point mileage, because that's going to be real important here in just a minute.
Key here is the trigger, and there's a point.
Oh, I love this hoodie.
So this time in the TechStream data, you could think of it as like a stopwatch. It's when it starts when the car turns on and stops when the car turns off. And then if it sees a triggering event, a T, it records that information. So this is when the trigger happened. So that's 1,142.2 seconds. And so I've converted that to minutes and seconds, because most people don't think in seconds. And so what it also does is once it sees a trigger, it's constantly circling.
This is the Toyota TechStream interface. This is not where the event triggers are stored. This is just the first part of the system when you first log into it, and it is on a laptop, and it is connected directly to Toyota. You have to be a Toyota tech to operate it. Nobody else can get it but a Toyota tech. It stores everything about the vehicle, and when it triggers an event, it has the time, date, mileage down to the 10th of a mile, because that is going to be real important when I bust apart Judson's presentation, what I'll call it. It's a presentation because it is not facts. It is his opinion. He really doesn't know that much about cars. He thinks he does, but he doesn't. Anyway, this is what the interface looks like. This is the first page you see when you log into real Toyota TechStream, but this is the older version. The new Toyota TechStream is global Toyota TechStream system, which I'll show in just a minute. This is just more of the parameters inside of the older Toyota TechStream. This is like the trouble codes, and like if you're looking for a problem inside the vehicle, you would navigate through here. I'll have to show the actual TechStream events in another video. This is just a short one. I want to get it out. So hopefully somebody from the team will see it and they can question what he's doing. I don't think he even knows what he's doing, to be honest with you, with Toyota. This is the new system.
Or that's when the trigger is. Sorry, 10 minutes, 57.4 seconds. Again, the trigger has plus or minus. So that's from 10 minutes, 52.8 plus 10 seconds.
What he has done here is take Burgess's information and put it on his own graph.
Mm-hmm.
Okay, this is what he is claiming is 1162.1, which is the 3-point turn. He's claiming she was driving down the street at, 9 miles per hour to 15 miles per hour, turned in a driveway to do a standard 3-point turn. Mind you, this is in the snow on a street that she's never been down. It's dark. So she pulls in the driveway. He's saying that she pulls in, shifts it into reverse, and guns it 50% throttle backing out of a driveway, turning the steering wheel. Now, if she pulled in a driveway, right here's the 50% throttle. If she turned in a driveway, put it in reverse, and stabbed the throttle to back out while turning, her car would have spun around and probably have done a 180, at least a 90-degree turn, sliding, mind you. There's no way there was somebody pulling in a driveway to do a 3-point turn and use 50% throttle backing out.
Time of 12/12/36. The TechStream data basically turned on, plus or minus a little bit.
When you say the TechStream, is that relative to when the car?
Now, if you remember, I said earlier about 10th of a mile. He doesn't list the 10th of a mile because there isn't one listed.
Okay, so again, we are looking at event 1162.1. The information in blue is speed. It comes out of the TechStream in kilometers an hour, converted to miles per hour, feet per second, looked at the total distance traveled, shift position. So in the TechStream data, a shift position of 1 indicates you're in drive. The shift position of 2 indicates you're in reverse.
There's no zeros. What would a zero indicate?
0 is usually neutral. And I believe 3 is park. So So there's also data on the acceleration of the vehicle. So basically, what is the effect of whatever you're doing in terms of stepping on the gas or not stepping on the gas? And then there's also information on the steering of the vehicle. So again, there's trigger 5 seconds before, 5 seconds after. So over here, a positive number equals a leftward steer. So you can see we have in the forward velocity or forward motion in drive, goes forward with leftward steer, stops, shifts into reverse, and then continues with a rightward steer back.
Now, what he has done to be deceptive is leave off the 10th of a mile, because she had to drive from where she did the 3-point turn to in front of 34 Fairview. From the point they pulled out of the 3-point turn to drive to the Albert's house is several tenths of a mile. So the odometer would have been changing. Of course, that didn't happen because the car was stationary in the driveway with only the tires spinning. And that is very deceptive and very dishonest. And we know why he did that, so this would fit the narrative. Furthermore, why would anybody back out of a driveway on a street they don't know, punch the throttle to 50%, which would have shot the car backwards while she was turning, so it probably would have spun around. Just very dishonest. But what do we expect?
When you look at the number 1162-1 as an event, can a key cycle, or when a car is turned on, power ignition on until the point is turned off, whatever amount of time, can it have more than one triggering event?
Yes, you can have lots of triggering events. In this case, it has 2. On a key cycle 1164, there's 11. On 1167, there's 10.
If you could move a little bit to the right on this, is there something you can see on here that caused the triggering event, some of the data?
Yes. So if you look at the triggering, the indication of what this trigger was, what you see is accelerator opening ratio, which is basically, you can think of it as how much you're stepping on the gas pedal. And so if it exceeds, in this case, 30% quicken time after shipping into reverse, that tells the system, hey, we might need to start recording this data. So what you can see, went into reverse, and then within a very short amount of time, the accelerator pedal went above that 30%. That's what caused the T or the trigger in the text stream data.
The row next to the 31.5, engine RPM data, can you explain to us what that is?
Sure, that's how many revolutions per minute the engine's turning.
The more gas, is it generally the higher the RPM?
Correct. There's going to be a little lag. Your car doesn't move instantaneously. You have to step on the gas, then the RPMs go up, and then it starts going faster.
If you could explain to us the total distance and distance travel column.
Brake oil pressure. We have the acceleration data here. And then from that information and using the acceleration data, calculating the speed at which it's backing up. The reason we have slightly different calculations here is we have some evidence that the wheel's slipping on the ground. So we need to use the accelerometer because the wheel speed is simply telling you the speed of the wheel. It's like if you're stationary burning rubber, the speedometer reads a certain speed, but you're not going anywhere. But the accelerometer tells you how much the vehicle's moving. So from all that information, we get information on how far the vehicle's traveled. We've done it in terms of total travel distance. We've done it relative to the start position.
But he didn't put the real mileage down because the 10th of a mile would have changed several tenths because she drove from the 3-point turn to the Albert's house. This was all just smoke and mirrors. He took Burgess's data, made his own little graph or chart here, put some of his information in it, and is trying to put a woman in jail for the rest of her life over faulty data that he knows, he has to know that he's wrong and he's not telling the truth. There's no doubt about it.
I'm sorry, being
Three-point
called
turn
loud.
triggering event.
I don't think he thinks he's wrong. I think he's just
There
a
is a
fucking idiot.
time in red, 12:23:38.
Correct?
Where's that time taken from?
That's coming from the cell phone of Mr. O'Keefe at 0.154.
Okay. And is there another time on there?
I mean, I do the math between those two.
Okay.
In the light above it. So, and cause damage to his vehicle. Where it is on the rear of Mr. O'Keefe's Chevrolet. You see it's about 25 and a half inches above ground, 32 and a half inches above ground.
Sleuthie, did you pause it?
No, that's his video.
Sleuthie, did you really?
Yeah.
Oh.
I have something to show you when it's over.
Now, this is where I know he's straight up lying, because both vehicles have urethane rubber bumpers. Both bumpers give several inches. So when she backed up against it at that angle, her taillight hangs out so far that it would have hit right where the Chevy emblem is, where that chrome strip is on the back of it. But both bumpers would have deflected, allowing the taillight to hit. And as far as that reflector on the lower bumper, that's in the more of the straight back of the truck. So at the angle that the vehicles collided with each other, that light wouldn't even come into play. Once again, he's being deceptive with the angles. At that angle, this is just a representation. At that angle, the very back lower reflector light will not touch. Furthermore, he's not showing this angle of the truck, showing how far that taillight actually hangs over. There is no doubt in my mind that that taillight collided. Both bumpers on both vehicles are polyurethane or urethane. They're like a rubber. They give several inches, especially with 7,300 pounds hitting 6,500 pounds. It doesn't matter what the speed is. It matters the force of the two vehicles pushing each other. It could be 0 miles an hour. The taillight hangs over far enough with the give of both bumpers that the taillight is going to hit and it is going to break. And that lower reflector, it doesn't matter. The angle that they hit, that wouldn't even come into play. Plus, that's flexible anyway. It's just a reflector. It's not a taillight. How much money are they paying a guy to say stuff that is wrong? How much is he getting paid to put a woman in jail for life for something she didn't do? And this guy has to know she didn't do it. He had to have seen the videos that are all edited and blurred out wherever they show Karen's car.
Where it is on the rear of Mr. O'Keefe's Chevrolet. You see it's about 25 and a half inches above ground, 32 and a half inches above ground. Here's Mr. O'Keefe's vehicle. So these marks are this is the Chevy Traverse words, are approximately right here. Again, I had the opportunity to inspect Mr. O'Keefe's vehicle. There's no damage where these marks are. So sure, it knocked the snow off, but it wasn't sufficient to cause damage to his vehicle.
This guy's a fool. As far as the taillight sticks out, it definitely made contact with John's car. He's not showing the proper angles, and we all know why he's not showing the proper angles. All he had to do was back them up against each other, and we would have seen that they would have touched. But no, he's got to show us pictures of them several inches apart because he is a deceptive man. He is very deceptive. He is not telling the truth whatsoever. You can see the angle right there. They would have made contact. They both have urethane bumpers. Both bumpers give. The taillight would have hit right where the Chevy emblem is. Just look how far the taillights stick out. There is no doubt that that struck John O'Keefe's car and caused it to crack with the two pieces that Karen said she pulled out. There is no doubt about it. That's what happened. And this guy is showing us deceptive pictures. He's not showing us the 1/10 of a miles on the mileage. He's not using real Toyota TechStream. He is lying about everything. In my opinion, he is a fool. Complete
so nice.
fool. He's deceptive. I don't know. I don't see how a person like that sleeps with herself, but it's not for me to figure out. But that bottom reflector wouldn't even come into play at the angle. The vehicles were almost 90 degrees apart. That would not matter. The bumper would have pushed in a little bit. John's bumper would have pushed in a little bit, and the taillight would have made contact. We all know it did. He's trying to lie to the jury and say that it didn't. I don't know what else to say.
Tail light, but yet the lower tail light also was not broken. Here, okay.
His arm. He's got a cracked, broken elbow. His elbow is broken.
Oh, this is from when he had the
Bones in
car
the
back
forearm
into it.
are completely into.
The tail light.
Yeah.
That was just from the impact. His wrist is broken. See the bone dislodged right there? That's gone. That knuckle's damaged. His thumb fractured.
It's looking a little weird to me.
And these 2 fingers are broken, along with this knuckle. No, that knuckle's intact, I think. That knuckle, yeah. That finger's broken, though. His finger's broken. Clearly see it sticking outside. This finger's broken. Not completely. Right at the second knuckle, the second joint. Middle finger's fine. But the fractures right here, those are definitely from the impact and the broken elbow.
Be in trouble. I think you're gonna have to do it like your hand is extended and then you have to spin around with the jelly.
Right.
And do some pirouetting and then get 7 feet away from the car somehow. So I want to talk about this real quick because he brought up the backing into John's car again. So in theory, if Karen Reed hits John O'Keefe at 34 Fairview and busts her taillight, essentially shattering it into just tons of pieces, right? That's the theory. So then she drives back to John's house. She backs out and she hits John O'Keefe's car. We're now at a point where nobody's even disputing that she hit the car. Last year there was like, did she hit the car? Did she not hit the car? Now everybody's on board with the fact that she hits the car. If the tail light is already so broken from hitting John, why doesn't any tail light fall off when the car hits John's car? If it's just ready to go, it's just so easily falling out from the flagpole to the fire hydrant. There's just pieces all over, right? So it's fallen out whether she's either when she's backing into him or when she's leaving, and now it's already cracked and there's just pieces falling out all over. There should be like a whole fucking trail.
Yeah.
Why wouldn't any of it have come out then when she hits the car? Just the little piece that we see. They didn't show it yet in this trial, but in the Sallyport video, we see the piece that falls in the Sallyport. Remember? Do you remember that picture? And it's like, here it is, and then all of a sudden it's down here from last trial?
No, I thought that, no.
Do you guys remember what I'm talking about? Does anybody in chat remember what I'm talking about, or am I just making shit up when it comes to that?
I remember this trial.
They had the piece. Was it? It wasn't this trial. It had to be last trial.
I remember this trial. We saw snow falling.
No, it was it was a photo of the vehicle in the Sally port where there's a red piece and then there's not a red piece. And they said it's because it fell out there or it had gotten loose there.
I don't know. I also know there were
Anybody-
bags in this trial that pieces were falling apart.
Trevor says it's a minor point, but the traction control is a major thing, and many in here last time kept bringing that up. I agree with you, Travis. Cat on the right side of the car in the Sally. Yeah, remember there was like a red piece, and then that red piece is like moved. There's a clear piece on the left that was not found.
Right.
Last trial, they showed and talked more about the boo-boo when the criminologist couldn't remove the taillight housing. No. It was the photo of the right side of her car. It wasn't the Sallyport videos. It was photos from the Sallyport. Let me see.
I was gonna say we have all the exhibits,
Yeah, let me go look.
but also look, I want to show you something.
Okay.
This
I like that hoodie. That's your battery, Daddy?
Yes, it even has like a battery tester. It also has a backside. And you know when you get like toys for the kids and stuff that like there's little tiny screws. It
Yeah.
comes with like the little tiny screwdrivers also. Yeah, it's the battery, Daddy. See?
Well, I thought you meant something else, but
No, you should get you one of these.
I should get me one of those.
See, Travis said, see, people know.
Travis, you even have a battery, Daddy? What is this world coming to?
It's actually really amazing. Like if I go out and I remember, so like right now, I need like, I don't need any double A's, but like I need triple A's, C's and D's. I did have D's, but like then something random needs it. Like my trash can is one of those censored ones. Well, it takes like 8 D batteries, like an outrageous number of the biggest batteries you can buy. So when I go out, I'll grab some, put them in here. It's
I
pretty.
don't think I have anything that takes D batteries.
It's actually really cool.
All right, here's the bunch of pictures. Let me see. Okay, so does somebody remember what I'm talking about? Has anybody confirmed that I know what I'm talking about, or no, not yet?
No, not that I've seen.
Okay. Okay, I'm going through exhibit photos from last year.
Yeah, Fern's mom, it's like a automate, like you wave your hand at it and it opens the lid. So it has to be battery. It has to have batteries. It's annoying like when you walk past it and it opens, but it's nice when like if I'm cutting up chicken or something and I want to throw it in a trash can, I don't have to touch anything. My Tootsies are cold.
They need a hoodie.
Well, I have slippers on, but I went outside. It's going to rain like for the rest of my life. It's been raining since yesterday. And so they open too. Oh, yeah. Let's see about jury reactions.
We don't have to go back and look at Maureen's testimony. Maybe was it Maureen?
Welcher was whistling as he entered the courthouse this morning. She said, so if you're watching or listening to this bias questioning, how is it hitting for you? There are several jurors who look very interested and attentive. A lengthy pushback from Welcher in answering questions that I think are the foundation of the first chapter of every middle school science textbook. As Attorney Little hands Alessi a document as he asks Welcher about payment for their work, one juror has a look of anticipation. Welcher interrupts Alessi to correct how long he has been working the case. A juror is smiling, taking notes. Lots of nods from the jury and a couple of smiles when Welcher finally answers that the state will pay the difference of the resale of the Lexus. One juror is nodding up and down as Alessi pressures Welcher on payment and contracts. Some jurors look confused. This has been going on for more than 30 minutes, and Welcher is resistant to answer questions about issues that are not in dispute: the scientific method, payment for services, the contract. I'm predicting Buchanan-esque responses to the rest of the cross. Judge instructs Welcher to refer to the report, get the answer, give the answer, and close the report. There's one juror who looks entertained by Alessi. One juror looks like he's ahead of Alessi. Judge again admonishes Welcher.
One juror looks like he's ahead of Alessi, like he already knows where he's going.
Yeah. Judge again admonishes Welcher for using his report again, tells him to close it. 12 jurors taking notes during the clip testimony. I wonder if Aperture makes money on the resale of the Lexus if the taxpayers of the Commonwealth will get the profit. At mention of Burgess, a juror smiles and puts his head down to write. Most jurors taking notes. I've noticed that jurors certainly took the judge's instruction about expressions seriously. I've noticed a couple of jurors having an unconscious facial expression, then immediately putting their head down. Jurors are very attentive during the key cycle question and testimony. Jurors are paying attention and taking notes except for one. Judge is directing Alessi as to what words he can use in his question. Struggle now between Alessi and Brennan. Jurors are paying attention. Another objection from Brennan.
Well, I do. I feel like Alessi is struggling, Chelsea. I do. I'm in agreement. I can't. At the beginning, I was trying to figure out, like, is there a tactic to this? And by struggling, I don't mean like he's doing a bad job. I mean struggling by Alessi standards.
I think he just wants him to directly answer his questions so he can move on to like the other stuff.
I think that he's having a hard time communicating with this witness. I would not necessarily think that I don't think Welcher's doing a good job though. Maybe just because from yesterday, he's such an idiot that it's hard to take anything he does seriously. So I don't know. Unless he went to lunch, maybe he got some food and he's ready to go. So you never know, because it was like with Burgess. The first day with Burgess, he was on fire, and then the next day he was more chill.
Right. This says Welcher pulls out a calculator while Alessi asks about Newton's laws. Alessi tells him he can't do that without the court's permission. 10 jurors taking notes during the force calculation testimony. Welcher explains G-force to the jury. Several jurors writing vigorously as Alessi lists calculations. One juror is holding his clipboard with his notebook up in front of his face as he writes in it. Some jurors are definitely following this testimony. All jurors have been awake and alert since I entered the courtroom. Many jurors write in their notebooks when Alessi cites the age of the report. at 49 years or whatever he said. Welcher finally answers that he doesn't know what the current reports say about what common injuries are from pedestrian vehicle collisions. Jurors are ping-ponging between Welcher and Alessi during the discussion of Welcher's visit to Fairview. Welcher testified he doesn't know where the impact was, road or street, that his feet were not on the curb. There are some wide eyes in the jury. One juror, who has barely moved or shown expression, is very attentive during Welcher's answers to Alessi's questions about what he knew and didn't know about the location of the vehicle and John O'Keefe. And then the break for lunch was 46 minutes ago. So, like, surely. Do they get 45 minutes for lunch or an hour?
Well, she normally tells them 45 minutes, but then they're gone for an hour.
That's so annoying. I feel like if you were to add all this up, they are in breaks and sidebars and lunches more often than the testimony that they hear.
Oh, gosh, yes. I'm still
We
looking
don't
for this.
take, like when we stream, when we start like an hour late or whatever, like we stream straight through. Like we don't take breaks.
Yeah, no, I need some food.
I mean, it's a little different that like, I mean, I can fix something and then eat it at my desk, but like, I don't know.
Barb said 50 minutes for lunch today. It doesn't matter because they never actually go with what the lunch is supposed to be. So it's always an hour or more. She never, if it's supposed to be a half hour, then it's 45 minutes to 50.
Yesterday was an enormous waste of time.
Unless you really like the Blue Man Group.
No. Oh yeah, Nunya, you know I pee a lot too.
You do pee a lot.
I drink a lot.
Is that what it is?
Mm-hmm.
What are you drinking? Water?
Small water, cran grape, Diet Dr. Pepper.
Oh, cran grape would make me pee a lot too.
Dude, cran grape is so good, but I only have one a day. And then a lot of times, like when we're doing this, if I have to switch loads, like if I'm doing a bunch of laundry,
Mm-hmm.
I like stop at the bathroom anyway. Just see. Like when you're kid, you're like, go to the bathroom before we leave. And they're like, I don't have to pee. And you're like, well, just go sit there and see if pee comes out. And like, it always does.
Going to do the laundry. You know what? I'm right next to the bathroom. I might as well pee real quick.
Yeah. Because then I won't have to come back down and then
pick it up again. That's just out of
like,
laziness. I'm like,
yeah, like I don't want to have to stop again or walk away from it again.
Okay, maybe it's not in the photos, so I'm gonna have to go check Maureen's testimony and see if it's there. Because maybe he showed it to her. He would no, the video is not clear enough to show it. Nobody remembers what the hell I'm talking about, huh?
No, it's quite possible you made it up in your head.
That's why I'm like, did I fucking dream this?
You might have. What was the whole testimony about him getting an email from an internet troll? Like, what the fuck was that about?
I don't know, an internet troll. I would love to know.
Random.
I would love to know if like it's somebody that we actually know and that the courtroom doesn't like.
Wouldn't it be hilarious if it was the turtle?
That's what I was wondering. Like, so because he knows this case now, he knows who that is. You know what I mean?
That is so funny.
No, I was talking about pee and I gotta go pee.
I need to find different slippers or a pair of socks, like the ones with the little rubber on the bottom.
Yeah, we don't need a slip and fall.
Yeah, I don't want to fall.
Okay, I'll be right back.
Okay. Mm. I'm just looking through Twitter. Mm-mm-mm. Who was the other person besides Sue that does? Oh, but she's not in there. I don't think Jessica Machado is not there, right? They like stopped letting her in. Oh wait. Mm. This is a little strange. Okay, so 3 hours ago, Aiden said, I was 11th on the list, did not get into court. 6 of the 10 winners showed up. Took me 2 hours. I don't see why I wouldn't be able to do that tomorrow, blah, blah, blah. Jess is not in. It says, so 3 hours ago, also, weirdly, Sue said, I'm on the backup alternate list for press access to today's Karen Reed trial. I will know by 10:30 if I'm in. And Jessica said, what is the backup alternate list? And we know that Sue got in because we just read her things. Jessica said, I'm just not understanding. Since when are those passes available if alternates don't claim them? What time are they giving the alternates until to get them? Do you have to sign in, check in? Where are the fucking rules? Yeah, I know she has an in weeks. And it seems like they're just not giving like everyone instructions on what it is that they need to do. So like if you do a lottery and 10 people win and you start court at 9 and by 10 o'clock, somebody that won out of the 10 people that were drawn in the lottery aren't there. I'm sorry, but that should be going to somebody else. Now, I don't know if you're going to draw another name or if someone's physically present at the courthouse and they're like, hey, I'm here. I want to go in instead. You let them in. I don't know. Are we about to start again? Oh, court will resume at 1:50. What time is it? It's 1:54, you fucking liars.
You fucking liars.
They do nothing but lie. Nothing but lies coming out of this courtroom.
I got myself a little snacky. That's interesting. They've purposely been keeping them both out.
That's what I feel like.
Well, yeah, for sure.
Well, if she goes in, then Grant can't. You know what I mean?
Well, he shouldn't be able to go in at all. But
What's today's date? 28th.
It's not a ho-ho. I haven't had one of those in years. Isn't that what Peggy Bundy always ate? Didn't she always eat ho-hos? What did she always eat? Ding dong. What did she eat?
Oh, I don't know.
Bonbons. Yes, it was bonbons. No, this is a much healthier little snack. It's like a little tuna salad kit with crackers. What do you guys think about Twinkies? How do you feel about Twinkies? I think Twinkies are fucking weird.
Like sponges.
Oh, they just like they never go bad, dude.
Ew. If something never goes bad, that's really bad for you. Should go bad sometime. Jesus. What all preservatives are you putting in it that it don't go bad?
I won't eat Velveeta. I won't eat Velveeta cheese because I think it's fucking weird that cheese can sit on a shelf.
Oh, I know. That's just like, have you ever seen those like little meals that have the meat in them that are on the shelf? They're like, oh, what the hell are they called? They're little tiny meals. Some of them contain meat, and I'm like, ew, what? Meat on a shelf?
Dude, when I went to Spain, all the meat is just there. It's just all on a shelf.
Disgusting.
It was
I also
gross.
get weirded out. I get weirded out about Yoo-Hoo's.
Oh, that's chocolate water. We call that chocolate water.
So it's not milk at all?
No, it's water.
So that's why it doesn't have to be in the fridge?
Right.
My kid loves that shit.
Yeah, my kids too. You couldn't function in Texas without Velveeta, but Velveeta's fucking weird because like it's cheese. Why is it? It's like, and it jiggles, like it's jiggly, and it's like, who wants to eat warm cheese that's been sitting on a shelf? Like that's gross. Yeah, Google it. Twinkies will outlast a nuke, for sure. Shelf cheese. It's not cheese. It's orange-colored oil.
Ew, gross. Okay. All right. What are we doing here? They took away their elevator music. Dude, I need to stay off Twitter.
Okay, so you can put Velveeta in queso. I understand that. I get that, but I'm not really a huge fan of queso unless it's got like taco seasoning. Then I can handle it. But I'm not even a huge fan of queso. I'd much rather go with nachos with like shredded cheese all over it. Now that shit's good.
I love cheese, but
I love it.
Since I've started my stuff again, like cheese, like I want it, but I have to be really careful, or it can make me like super sick. And another weird thing too is salad. Like, so I love the chopped salad kits at the store, the chopped ones. So I get like the chopped Caesar ones. They're really good. And I actually just got more, even though I already like, how ridiculous is that? I already know it's going to make me sick because it made me sick last week when I ate it. But I'm going to do it again anyway because it was yummy. And like, as I was sick last week, I was like, oh my God, this is the wrap that I made. Like, I'm not going to be able to eat it ever again. And like, here I am. I put in an order to pick it up at 4:00 at Walmart. So,
It does smell better, but I'm lazy, Eunice.
what does?
She said, like, shred your own cheese because it melts better, which is true. It's absolutely true, but I'm lazy. The other issue I have is I really like shredded cheese. Like, if somebody is shredding cheese, I am the person who will go up and take a handful of that shredded cheese and piss people off.
Who does that? I don't think it was the lettuce. I think it was like the dressing. Like, something about it just didn't. I think it was the dressing, like not sitting right in my stomach. Because, like, I don't know if it's too acidy or whatever.
You can't eat salad? Oh man, I love a good salad.
I won't eat salad dry. Like, I know people who eat salad with no dressing, like fucking weirdos.
I don't know if I could do that. I've never really tried. I think it would have to depend on the type of lettuce. Because like iceberg lettuce is like super water. Like it's mostly just water. There's not a lot of nutrients in like iceberg. I could probably pull off like a romaine.
No, I'm not a rabbit, dude.
Yeah, I could do it. I could pull off like a romaine or like a spring mix.
Oh, with no dressing.
Yeah, I think I could. I mean, when I think that, like I said, like iceberg lettuce would be easy because it's just like water. So
how is it not so dry? No, it would feel like eating grass. It would feel like going outside picking some grass. No, it's too dry. Like blades of grass in your mouth.
I used to buy like the bag of salad, like just a regular garden salad, and I would take dressing and so I'd cut the top off, pour it in the bag, mix it all together, and that's what I would eat for lunch, just straight out of the bag. Just like the entire bag of salad.
Oh, we used to grow lettuce and it was so good. Oh, we used to grow green beans too. Dude,
oh, you get
fresh green beans. Oh my God.
Oh no, snap peas, baby. Oh,
ew, I hate peas. But
fucking
green
love
beans,
them.
dude,
Oh,
I could eat.
straight from the garden.
My kid acts like a freak now. Like all the things he ate before, he won't eat now. Like rice, Chinese food, green beans. He used to love green beans. Dude, my kid, I could fill his tray, his high chair tray, with green beans to where you couldn't even see the tray. And he'd sit there and just handfuls and just eat it up. Loved it. I used to make.
Oh, that's good stuff.
Oh, it was so good. Like I could eat a whole bushel of green beans. Like that's how delicious they are with like bacon in them.
No. My mother-in-law puts bacon in them.
Oh, so good.
If you cook the green beans with the bacon, it's impossible to have crispy bacon. And I fucking hate gooey bacon. But if you know anything about me, here's something to know. I like all of my meat overdone. It pisses.
Oh, you're crazy.
If I go to a restaurant, I order a filet mignon, I tell them to butterfly it and cook it double well done.
Shut up.
No, baby. I do not.
Oh
I don't
my God.
pink on that. If I see pink, it's in the trash.
Oh, I'm so disappointed. Oh, so is Nanya. You're dead to Nanya.
I am dead to a lot of people. My husband is like a meat connoisseur. So like, he's got like the barbecues and the smokers and all the things. And he gets so mad that he has to cook my meat.
Medium rare, me too.
Yes, you do. Even when it wasn't cooked enough, you put it in the pan for me.
Medium rare.
No. Yeah,
I don't. No, absolutely not.
No wonder you can't eat lettuce. Your stomach's all fucked up from having raw meat.
Not raw, but like I'm sitting here, my jaw hurts just thinking about how much you got to chew your steak. I mean, what?
No, you have to chew it a lot when it's pink. It's all chewy and rubbery. Like that's so gross.
Teresa.
Anything underwell is wrong.
Like, I mean, my burgers and stuff, I don't like them to be pink or anything like that. But like my steaks, forget it. If I overcook a steak, I literally won't eat it.
I don't even want juicy chicken.
Ew,
Like,
dry.
Like, I just give me beef jerky. Like that's
and
what
like
I like.
dry pork chops too. Ew.
Oh, they're so good. Those little tiny ones, and you can just pick them up and like eat them. Yum 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 yum.
Oh, Teresa.
You see it for the session.
Juicy
What are you gonna
chicken
do
is
when
the
you're
worst.
old? How are you gonna chew something like that?
I'm gonna use my teeth.
What if you lose your teeth? Dentures ain't gonna chew through well done.
I'm gonna eat a salad.
Oh yeah, the sear does matter.
I don't even like fucking chicken. Let me just be clear. If I didn't ever eat chicken again in my life, I'd be fine. But my family fucking loves chicken. It's so
I
crazy.
will say that the sear does matter. Like I do not like a soft outside of the steak. Like I like a medium rare, but like you gotta get it like crispy on the outside.
Nope, just well done.
And
We
I
have-
love Montreal
For
steak
Christmas,
seasoning.
my
I'm a
brother
weirdo.
loves to make a fucking prime rib. It's the grossest shit to me.
Yum.
It's so fucking gross.
Oh,
So
it's like
he'll
special
take
occasion.
one of like the end pieces and he'll sear the shit out of it so that I'll have dinner. So he'll put it like in a cast iron skillet and sear it for me.
I actually, within the past year, found like the most perfect recipe for pork, because pork chops, if you overcook them by 5 seconds, like I hate them. I hate them. So I figured out a way to make them in the air fryer with
Turkey dry, baby. Yeah.
oh,
Put it on a
God.
sandwich. Oh, it's so good.
Oh God. Yeah. We already talked about Liza's bangs. A lot of us are not fans, but we're fans of her, so
We do. We love her, but it's not the haircut's a no bueno.
I mean, I would have pinned them back. I mean, she must like them or she'd have pinned them back. You know what I mean?
Yeah, maybe she's feeling it. I mean, she went with a different color too, so she got it all done. Post punk mama, don't
It does
you
look
dare.
a little darker, doesn't it?
Yeah, it's got like a dark and then a highlight.
Yeah.
You don't do turkey? How do you not eat turkey? I eat seafood too. I'll even go with some imitation crab on a salad.
Now,
I
see, that
love
shit I don't
crab.
like undercooked. Like, I like tuna, like sushi. Nope. Tuna that's
I don't
not.
like sushi.
Wait, absolutely not.
I don't like sushi. No sushi. Oh, but like my mom makes like salmon patties. Oh shit, that's so good.
I
I'm gonna
love
need
crab
she's to make me
cakes.
some salmon patties because I haven't had those for a long time.
I obviously like crab legs and scallops, but scallops are another thing. Like, you can't, if you overcook scallops, then they get real rubbery and yucky. You can't do that either. Oh God. That's my mother too. Even hot dogs, like I would rather boil a hot dog than have one on the grill that's like all black.
I don't want it black. But I cannot. Do not boil a fucking hot dog for me.
Yeah, my aunt will be like, just keep it on, like hers stays on the longest, like it comes out and it's entirely black and like cracked. Ew.
All right, now I'm even hungry, and I just had my snack.
I'm hungry too. I'm about to put some chicken in the microwave, in the oven. I'm not going to overcook it though.
Okay, so Lacey, here's the thing.
Hot dogs are really not good for you.
If you eat a hot dog, I did it. Okay, so I didn't, and this has nothing to do with
You
this
can get
case.
turkey
So I don't
dogs.
know why we're like. I know that they're back, but we're okay with kind of being a little bit behind. If you eat a hot dog, you have to eat an all beef hot dog. So
Yeah,
Nathan's or Hebrew National. You can
do.
don't eat Oscar Mayer, crazy little. Those are who the fuck knows what's in that.
There are different kinds. People don't know that. Tracy.
Didn't know that.
There's different
So
kinds of hot
growing
dogs.
up, I would just tell people, I'm sorry, I don't like hot dogs. And they would be like, well, what do you mean you don't like hot dogs? And then every once in a while, like that would be like the only thing that like was at a barbecue or whatever to eat. So I would eat a hot dog and I'd be like, I really fucking like that hot dog. Like, I don't know why sometimes I like hot dogs and sometimes I don't. And then I met my husband like 20 years ago and he was like, there's different kinds of hot dogs. And I was like, what the fuck? What do you mean? And so he's like, yeah, he's like, we only eat like all beef hot dogs, like Nathan's or Hebrew National. And so that's all I've ever eaten. And I fucking love hot dogs.
The only
I don't eat them all
sausage
the
I
time,
like
but I would never, and I'm like, that had to be my issue, was not knowing the difference between a hot dog.
I like sausage, but I only like hot sausage. I don't like sweet sausage.
What do you mean?
Like so you know what sausage is?
No,
There's
Angel, we're just talking.
There's hot sausage.
You mean like
and-
spicy?
Yeah, hot sausage and sweet sausage. I like the hot
I've
sausage.
ever had sweet sausage. I mean, there's just like original.
Yeah, that's sweet sausage.
Oh, I like original. Or like I'm like really good with a cheesy brat.
Do you like turkey burgers?
No.
I think I prefer like homemade turkey burgers to regular hamburgers, as long as you cook them right. Like I had to get a meat thermometer for my turkey burgers because they're just another thing where like if it's overcooked even just a little bit, it's just not good.
I do love Italian sausage. Oh, pasta with some Italian sausage in there. Oh, that's so good. So good.
It's got to be hot. Like my family, if when they're cooking dinner, they like know that I don't want any of the sweet sausage, so they'll make me like 2 hot sausages.
Oh, see, this is really what it comes down to. It comes down to a texture thing. It comes down to a texture thing.
Well, sausage has that skin on it, like the outside of it is like a weird. I don't know how to explain it other than a skin. Like I know
they put it in the wrap. That's how they make the sausages.
Yeah. Sausages,
All right.
peppers, and onions. That's so good. You ever have you know what my grandpa's favorite meal was? And he'd only get it for like special occasions. Liver and onions.
My grandpa liked that shit too.
Cocky. I couldn't even smell. I didn't even want to be anywhere near the house when they made that. It just made me so sick. He had also had pig's feet before, frog's feet, frog's legs. Walmart. Oh, I like bacon. My kid loves bacon. My kid would eat a whole pound of bacon if I'd let him. He's leaving the room. Okay, let's play.
Let's go.
Now that we're all starved to death.
Yeah, sorry guys.
Just take a moment, Your Honor, to reorient. I'll be right.
He's nodding to himself. He's like, okay, yep, I do.
Have you ever had a galunki? See, now I feel like I need to cook. Like now I'm really hungry. But depression food. Listen, I know a lot. We eat a lot of depression food, like shepherd's pie. Like I love shepherd's pie. But have you ever had a galunki?
No. My whole family, like the older group, all like that sauerkraut with fucking sausage. Like that's so gross.
Oh, I do like sauerkraut, but a galunki.
No, what the hell is it?
It's like, well, you might not like it, but it's like meat. It's like meat, and it's wrapped in like cabbage leaves and cooked. Let me find. I'll find a picture. They're really good.
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same.
Nice to see you again.
Same.
We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on any
bones are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is either from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. what you're concerned about is where the center of mass is, but the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. Well, so let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay,
Tell me when you're ready.
go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right eye.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Is somebody clicking their pen? I think he's clicking his pen like he wants to write it all down. He's like, I have to be able to look at my notes. I need to be able to write notes. I need to be able to use my calculator. Have you seen my red stapler? Yeah, I'm surprised that AJ is not more involved in this. I thought this is definitely his cup of tea. He's not even allowed to have it. Oh, he does when he has his calculator. He's like, here, cosine. You leave Miss Tushy Bottom out of this, Nunya. She did nothing wrong.
Okay, question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You
Correct.
divide,
We're doing a little simplification in terms of the crash
Yeah.
pulse shape, but generally, yes.
right. So, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force the F you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
Nope.
do your calculation?
Nope.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, excuse me, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation, doesn't the literature tell you, can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load, a load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
Contact
Lexus
area.
SUV, let's assume,
Can you,
I'm sorry,
can you repeat the question, please?
absolutely, thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right? But let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testify to on direct, you don't know exactly where that point of contact is.
Correct,
You don't know.
except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers.
Okay.
Okay. You said 300 and 750. Did I hear it correctly?
You did?
Okay. That's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break
Jeez.
any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350,
300.
above 300. Yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was the, you said? You said
2,180.
dyslexic? Or do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about,
Gotcha.
okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight and actually close in age to Mr. O'Keefe showed
My God.
about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load in a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay.
Which
if
one,
you can hear
Travis?
my
Who's lost
question,
the
if it's
jury? That's
unclear,
where I'm
you
at.
tell me. For
Which
not
one?
a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a brake to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a brake to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me
Get
to
real
not
fucking tired of
include
this guy.
taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wolk, can you pull up a slide from Mr. Wolk's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Lessis?
Mr. Wolk does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
just to be clear, 2188 is a number I calculated for you. It's not, quote, my number.
I understand, but we did,
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that
I'm sorry, what, to the hand?
to,
Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes, yes,
Right here.
yep,
So that transition between the two body panels,
yes.
that could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail?
Corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep.
sorry,
track.
Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report. But
Yes
they
or
didn't
no?
actually x-ray from the records I've seen either his hand or his arm.
Sure.
So there was, at least
my
according to the
God,
autopsy
dude.
report, no overt fractures. But the x-rays I saw, none of them were the arm. And the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence
Like we literally heard the ME say he had no fractures throughout his body.
in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No,
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
not that I saw. Again, it wasn't x-rayed.
Was there any indication in
gonna punch this
the
guy in the
medical
fucking
records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Oh my
Correct.
God,
So-
dude.
Are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes,
And you're aware of it because you read the autopsy report, correct?
correct.
Are you implying, and it's a question, that Dr. Shorty Bello missed?
I am shocked that Alessi so far has not been like, sir, yes or no.
Yeah, I don't know
And-
how he's not. How there's not a sidebar where the judge needs to direct this fucking guy to
Answer.
just answer the fucking question.
Like, why does he have to
Why is
reword
he
every
so
question?
argumentative about every single question?
He is. So I get what people are saying, and they think that Alessi's like I don't know, beating around the bush or something, or trying to trip him up in tan or whatever. But I personally don't see it that way. If I was sitting here as a juror, I would be so irritated that I just listened to this man for an entire day talk normal, answer questions normally, yes or no when it was appropriate on direct. And now we're sitting here and quite literally not a single question has gone by that he has not felt the need to reword or provide extra explanation. I'm shocked that Alessi has not said, you can redirect, you can give additional explanation. Please just answer the fucking question, yes or no.
The only problem is that with this witness in particular, the defense has not been able to win really anything when it comes to Bev. She's allowed everything when it comes to this fucking guy, except for a header.
Like, I think he needs these things to continue on in his question. Like, he's trying to continue on in his questioning, but he needs to get these questions answered. And because he's like not answering, then Alessi's stuck in these weird middles because he refuses to fucking answer, so he can't move forward.
100 agree.
So, like, I think that's what it is. And so now we're going to be here for 7 days because he can't just answer. I think he's doing it on purpose too, Gabby. I would 100% think he is doing this on purpose. Welcher is doing this on purpose.
Oh, probably.
And the comment about what did he say? Dyslexia? Would you say dyslexia? Fuck, what the fuck are you talking about, sir? I mean, that was just to be rude.
Yeah, I don't know where the jury's at with this. I don't know if they're. I don't know. Yeah, I would be curious.
Before lunch, they were following along. They were interested. So, like, the jury wasn't lost before lunch.
Okay.
According to Sue. Someone said 4 minutes ago, or someone said 6 minutes ago, that one male reporter, John, says they look bored. Do they look bored to you? And Sue said 4 minutes ago, hard to look bored when the majority of them are writing in their notebooks, the majority of the time. But 5 minutes ago, she said, sidebar, definitely low energy in the jury box. So, which is, sidebar. We're about to be there. Hold on.
Implying, it's a question, that Dr. Scorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir,
you are a fucking idiot.
Ask me about the opinion of a medical examiner. I'm not a medical.
Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
He said enough. Yeah.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam
I
Clerk.
understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
No.
That was not your original question, but to answer your question, no.
Yeah, that was.
Except for the skull.
Fucking idiot.
Except for the skull.
Correct.
Could have just fucking said that, and we would have been done with this fucking line of questioning 20 minutes ago, sir.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Oh my God.
Did you read the conclusions of Dr. Scorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
No, not objection. Are you aware that the ME says no, and that the cause of death is undetermined? And so you're saying that you take all of these things into consideration, but yet you're sitting here saying that he was hit by Karen's car.
Right.
I cannot fucking stand this guy.
Me either. Oh yeah, I hate the bangs. I'm sorry. I'm not gonna say another word about it.
Or what?
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise. You did not present, as you have stated, a force
You don't need to fucking write
calculation
anything.
with
Put the
regard
goddamn
to
thing
the
down.
arm.
Sorry.
You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay.
Oh,
wanna
you
call it a
motherfucker. I cannot stand this
test?
man.
Sure.
Okay, let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Yeah.
So,
because you
your
don't
blue
agree on
paint
anything.
test involved painting the right rear tail light blue, correct?
Correct.
Positioning the test subject behind the tail light,
You.
correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one,
Okay.
okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that
Yes.
arm?
So generally, I wanted to show that the location, area,
His
and
body's
span
inverted.
over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No, where'd you get that from?
Hold
Oh,
on.
you-
Okay. The
what?
answer is no. So
No,
did
he
you do a
is
test
so-
involving 20 miles
So
per hour?
unprofessional. I can't.
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mhm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you do
course.
that? Okay. You
course.
didn't do a blue paint test with the vehicle going at 20 miles per hour.
No, we didn't.
correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles
Why? Because you think
Why
it would
not?
break your arm?
an hour.
You could have done other tests
With a dummy, maybe?
where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct?
Correct.
You
If
could have
you-
done that.
If you use the right crash test dummy,
Yeah.
and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is,
So you didn't do it because you knew that your testing would show something different. So instead, you conducted tests where you positioned yourself at a speed you could tolerate so that you knew exactly what would happen.
I hope that that's where we're ending up here because this guy,
is
I don't,
we don't have enough
He's horrible.
information to be able to conduct that testing.
Well, we got a lady on trial for murder.
So, your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
what?
You know, you have a hypothesis at what speed you believe there was impact. You have the point of impact speed.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
So then how are we saying
How
that
the
this
fuck are we
happened
saying that it even happened?
Talk about the other information you don't have.
Sorry.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege.
Oh my
there was
God.
a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I want to go through the information that you don't have.
Okay, dope.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. You don't have that information.
I don't have where it started.
Lawyer, said, you say the Lexus SUV drove over 20 miles per hour when it made contact with John O'Keefe. No, where'd you get that from? And then Peter said, that is what I thought his testimony amounted to as well. I guess I am lost.
I think we all are because that's what he said was at the time of the impact. It was 23.2 or something like that.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the
I'm
middle
really
of the
fucking
event.
tired of this guy's attitude.
Me too.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Wool gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, I think it was like a 30-something number and a 50 number, and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
You fucker.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolf, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All
I
right.
would let him have none of that
So
shit.
if you could zoom in, Mr. Wolf, so Dr.
Somebody
Welcher
tell this
can
guy that
see
he has to stop with the fucking commentary.
the numbers in the column.
You're going the wrong way.
Yep. They're to the farther to the right.
Oh, I'm not
Well,
the only
you
one that
can't
has
be
a problem.
trusted with your laptop, so.
Okay.
You still
Sir, do
don't
you
have it.
remember testifying about this to the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
Can
you
we
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. It's that, is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's see where the one next to it says minus 53.
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157.
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now,
That makes zero fucking sense because he literally said that it traveled forward for the 34 some odd feet and then backwards for 50 some odd feet, and that equals the 87 feet. Now
Correct.
he's saying the 87 feet is all rearward direction. That's not what you just said, sir. So you're saying she backed up. She was driving in reverse for a total of 87 feet? Is that what you're saying?
Is that what he's saying now?
That's not what he said 2 seconds ago, but that's what he just said just now, that it's all the 87 feet is rearward driving, basically.
Okay.
Can you
Hold on, to be clear.
34
So
feet forward, 53 feet back.
Yeah. But then that's not what he just said. Like he said that and then he said the opposite. So listen here.
that is so 87 represents the total rearward distance traveled during the trigger.
Okay.
So
And then
Wait.
50 something feet, that gives you the same result. So it went 30 a little bit
right here.
and see where it's changing directions at 34.157.
Yes.
So 34.157 is what he's claiming she drove forward in that
Mhm.
trigger.
Add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right.
Okay. You heard what he just said, right?
Yep.
Okay.
And
Same as yesterday.
what is the 87 feet traveled? Is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
So Alessi's saying that's the total distance traveled, not forward, not backwards, just total distance traveled throughout the trigger. So literally he just summed up what he just said, adding the 53 to the 30, whatever.
Okay.
That is so 87 represents the total rearward distance traveled during the trigger.
It's like he
Okay.
had to say the opposite of what Alessi said.
Okay.
Alessi summed up what he said.
And then he just argued it.
Yep.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you please-
Hold on, to be clear. So it starts, it pulls forward,
Hold
then
on.
it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet
Oh, I can't.
did you say on direct, and did you just say now that it went 87 feet in reverse?
Yes.
Correct.
Just said that.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet?
So basically what he's trying to do is put her very far forward so that her reversing 87 feet doesn't put her like past the driveway.
Okay, but then where's the 53 feet come in?
It's so what was the first number? 34. 34. So he's saying she drove forward 34 feet,
Uh-huh.
then drove that same 34 feet, drove it backwards. So she basically ended up at the same spot plus another 53 feet. So
in essence, then she drove
87 feet backwards. So pretend his face.
121 feet
No.
total.
Well,
Forward
yeah,
and back.
forward and backwards. Yes.
Yeah.
Like if his head is where she started, okay, and the flagpole's right here, and like the house is right here. He's saying that in that trigger, she drove forward towards whatever that other house is, maybe 32,
Uh-huh.
then stopped, then reversed 30, whatever, 32 feet back to where she was, plus an additional 50 some odd feet.
And doesn't hit the Jeep.
Doesn't hit the Jeep. Yep. Yep. So total from where she pulled forward to plumb where
It's
she
87 feet back.
Yes.
Got it.
Feet
Okay.
do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense.
Of course
Because
it
when
does.
it went forward,
It literally makes perfect sense. Forget the
I am
moving
so
forward.
tired of him talking to Alessi like this. I hope that
too.
Alessi's just letting him do it so that the jury fucking hates this guy.
We
It's
literally
the only thing
just
I can
had
come
this
up with on why
discussion.
he's not stopping the disrespect from this witness.
His answer is once she pulled forward a certain number of feet, she put the car in reverse and yes, reversed the total of 87 feet. Total. Yes. That's the answer. The question made perfect sense.
Then it went in reverse.
We fucking know that, sir. I can't. I'll be right back.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80. It went
Go ahead.
And then
sir.
I'll be right back. The answer to this, Teresa, should be whatever number you just gave us. The
121 feet.
Okay, now I'll be right back.
34 feet forward. Then it came back 80 or another 53 feet past where it went.
Exactly. So you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, I was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Why? What started the trigger?
Could you zoom in? There you go. No, go back to the left.
I really hope he makes
So
this
that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so
Ooh, that's what Be in Trouble
we
was
have
talking
the
about.
velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral,
I think it's either neutral or park, but I'm pretty sure it's neutral.
a 1 represents drive,
Correct.
a 2 represents reverse,
Correct.
or a 2 can represent slowing down. Is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down.
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But
He
the
said
brake
zero
switch
neutral.
and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay, so if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolf.
Burgess, you just felt bad for.
And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Leslie, so is this 30 or 31?
Yeah, I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do?
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
I'm glad we're
You do?
going. I'm glad we're
Okay.
going here.
So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
Use a
You're welcome.
formula in Excel or what?
Now, we're going to keep that up, Mr. Woke, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
No, it's a clock.
Not here.
See it.
You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Look at them.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%
So let's
in reverse.
Okay. Got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
I mean, it doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage, but it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yeah,
Yes.
we read their testimony.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this, Mr. Chairman.
Me at sidebar. I'm 3 milliseconds away from telling him to fuck all the way off. Please have an answer.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, am I correct in my understanding
Right, like
that
what are you taking notes for?
you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
More than that.
No,
87.
it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you
Did you test whether that Lexus, which you went ahead and bought, can reverse 87 feet and reach 24 miles per hour? Did you do that? That wouldn't have caused damage to the car.
stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time or
Yeah.
just?
Yes, 12 to 1.
Oh,
So Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front
A white
of
Jeep.
34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
Sure did.
the entire time?
No, I'm just talking 12 to, yeah, any time
Never.
between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any?
I can draw this guy. What should I draw him with? Like, what should be, like Lally has a paddle. What should this guy have? A pen on his finger?
The assumptions with regard to that.
At a point in time, there was a vehicle behind it.
I'm sorry,
What?
There was a vehicle behind it.
just one?
That is my understanding. In terms of on the street, is
On
your
the street,
question?
exactly.
Yes.
A Jeep, perhaps? A white Jeep?
And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Oh, okay, the truck.
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
Mm-hmm.
So I'm going to let that answer stand, what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision
Where's
of the
Peggy?
Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end or prior to event
The white Jeep,
1162-2.
sir.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
Fucking Sam.
Let's not.
I was just gonna say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front
On the road.
of 34 Fairview.
So this is why they never fought the white Jeep. They kept they don't care that the white Jeep is out front for this purpose.
Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather, I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is
Saying numbers.
within 65 feet of the rear of it, or whatever the numbers are, I would need my slides,
It was 50.
50,
Yeah, go ahead.
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
Because it's
It
not a
depends
straight road.
on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually
30
why I
some odd
have
feet
that
forward.
diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
Oh,
So
where's
if
that
anybody has
testing? I would
driven
love to
a
see it.
vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is
But you dressed up in the same clothes as John O'Keefe to do a test with paint?
Less than clear visibility.
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow,
Oh.
I've done it. But again, that's been decades.
Right. So
Sorry.
87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
And they would see where the wheel was cut to see if she was able to follow the curve of the road because the road's not straight.
Correct.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described,
Dante,
right?
Conditions
Whether
have nothing to do
I
with where
need
you
to
start.
finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him
Well,
finish.
fuck
his
up.
question.
Wait your turn.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting? You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
What?
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
Sir.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah. Highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality.
Yeah.
So
like a
in
total
terms
fucking idiot.
of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167.
You pause it real quick. When did he drive the Lexus backwards going 24 miles an hour?
I don't know. He said he did, but like I was waiting for him, for Alessi to be like, okay, where is that testing?
Why don't we see that?
Because he said that he thinks he said that he did it with this Lexus. So where is that testing?
He said he did 3 tests. We watched all 3 tests yesterday.
If I don't see him driving 24 miles per hour in reverse, then I don't believe that he did it.
Well, so did he just do it for funsies? Because he testified that he did 3 tests. And in those 3 tests, none of them he's going backwards 24 miles an hour.
Right.
None of those tests actually is he driving.
Right. True.
So when the hell did he go backwards 24 miles per hour?
I don't know, but he didn't ask. Alessi didn't ask. He should have. I mean, he still might, but.
Yeah, where is that? When were you driving it backwards 24 miles per hour? And where's the results of that information? I guess unless they already have the answer and they don't want that out. So then they might not ask.
Right. I can't stand him.
I know. It's so bad.
It makes me so angry. And that really was a dumb fuck comment. Like, into space, sir? What?
What
Really?
he's trying to say is that as an engineer, we can build whatever the fuck we want to build, and everything is possible. But as
Okay,
an
but-
engineer, we go off of probable. We don't talk about possible. We talk about probable. And so he's just talking like, you don't understand my lingo, dude.
What engineer, right? So I'm crazy. So if I'm an engineer and you come to me and you're like, I have this tiny bit of data. I mean, we've literally sat here and listened to him say, I didn't have that. We didn't have that. I didn't have that. That information wasn't available. We didn't have all the information. This is the limited information we had. This was all. So wouldn't you be like, kind of like what Dr. Rentschler did last year, where he was like, there's just not enough information here to be able to determine anything that happened. Yeah. Who just said he's said possible lots though, so he can fuck off. Just like
It's true.
no, we're not. No, Teresa, it's not an egg roll.
See, it looks like an egg roll.
No. So I don't know. He's irritating me. I have a feeling. So court's going to be over in 30 minutes. So I have a feeling he'll be back again tomorrow. It's 3:36 right now.
Oh shit. Okay. I got to leave in about 5-8 minutes.
Then when are you going to be back?
I'll have to probably, if it's done in a half hour, I'll have to end it. I won't be back till closer to 2 my time.
Oh,
So it's fine. I'll just join from my phone.
well, I'll try to finish him because I can't stand him.
Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know. I'd characterize it that way. What happens is, there's 6,000-pound vehicles coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir,
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay
You don't
with
know
this
the
slide,
answer?
Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
On the
sometimes it
image,
doesn't
the
show.
upper left. I mean,
Yes.
technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
The
I'm talking,
biceps goes all the way to the elbow, so do the triceps.
right, so I'm talking about the two that are the farthest up.
Correct.
All right, would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is
So
what I
wires
showed in my
the ones on
slide.
the forearm
My
the same way.
questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the
So the ones on the
6,000-pound
forearm
vehicle
do the
is
same.
going to push me out of
He said the forearm, you fuckwad. You're
The
still pointing
forearm
up
should
here.
be the same as the bicep.
the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
We already
Correct.
did.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay,
And my slide shows this quite clearly.
So you disagree, you do not agree that the injuries to Mr. O'Keefe's forearm under your theory would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm?
Yes.
I'm
This is
clear
what I
what you
said.
mean.
What I'm trying to do, sir, is to get under your theory.
What's so hard to understand? He's saying the tail light would have to maintain contact with his arm.
In order for it to go from point A to point B on any form of
Right.
laceration.
Right. Meaning, like, as soon as the arm hits it, it couldn't explode. It would have to stay, like, it would have to still be, like, he would still have to, his whole arm would have to make contact with it.
Theory,
Mhm.
right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break? The arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct.
And
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
so now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. But you
No.
didn't do that in your report.
Nope, always applied the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate
You called it a
height,
test.
position of the taillight relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics. I would say these are the numbers, but for example, the timing in GPS, how a clock times, the concept of a second, what does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my.
No, sir. He asked you specifically what page you refer to the laws of physics, whatever law of physics you chose to use in reference to John's right arm. It's a really simple question yet again.
Question. Where in
And no, you don't have to cite all physics. You don't have to do that. You just say this is the physics calculation or whatever that I use to determine this about his right arm.
your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
H.
2A, 2A Roman numeral 1,
Okay, what's the second?
2A Roman numeral 2,
What is the second?
2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
Oh, you fucking.
So let's go to
Oh.
3.
Oh, sir. Mm-mm.
You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where,
Can you read the next sentence?
I'm sorry, is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's
God damn.
go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree. I'm sorry, we'll take that down.
Hank, shut up. Shut up.
Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So
Oh my God.
horizontal motion generally will
Do you agree or disagree?
cause a horizontal laceration. You can get what are called stellate, which are blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause
So do you agree
horizontal lacerations.
Do you
But
agree?
when you have a fractured taillight, you can get pieces going off in other directions.
Sir,
So it's not necessarily going to be perfectly horizontal.
So my question is,
You
not with
fucking-
clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So
sure.
like, is it a clipping contact or is it not a clipping contact?
You fucking
Is it
tell
a
us.
direct in the center of the car impact?
Okay, are there only 2 variables you need to
No,
answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis
You don't have
of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations, but again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally,
Okay. Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the test.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it. But I think we've got a slide for you. And what number?
Dr. Welcher,
111 is on the screen, sir.
You are insufferable.
Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car is moving. is probably a little better representation.
Sir, I'm just asking you a question about this slide. If
Okay,
you could just
fine.
focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All right. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
No.
I have not. I've never
Yes, you
asked.
have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
You are the one who said maybe the tailpipe.
I am not going to be asking any questions that involve the taillight in any fashion. So what
Nope.
I'd like to do is to go back to the question that I'm asking,
Mhm.
which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay.
The
So-
sheet metal.
Are you saying that you considered other orientation of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in the Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method?
If I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from True Falls report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass top, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different. None of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I
Wait,
actually
this
don't
is-
know at this time.
I didn't know we were outside the jury's presence. Or did it just jump? Did it jump?
So
Okay, Mr. Leslie, hold on. We're going to do that for you.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally,
Okay.
I don't know where we were, but I have to go to the bus stop, so I'm gonna let it play. But I gotta go. They must have just ended the stream, so that's why it jumped.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing.
Can you hear me?
Just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
Yeah, I'm going to the bus stop.
Okay. I'm just trying to figure out, when did we go outside the presence of the jury?
It jumped, so right here,
Oh, okay.
and then it's just this little bit, and then I'm assuming it's not live anymore.
Okay. So we're back to where we were.
I think so.
If we could take a shot at it first, and then we may ask you for it. But I think we've got a slide for you. And what number?
I think this-
111 is on the screen, sir.
Or did I not go back far enough?
No, I heard this. So I know
Okay.
that we watched that for sure.
Okay, then I'm just gonna leave it at this because
I just don't know how much further we heard already. So whatever. Just play it from here so
The
you can go to
blue
the bus stop.
paint more predominantly on your upper arm than your forearm.
yeah, I remember this. But
Outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes.
I hate you. I hate you.
So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion. So what
Yep.
I'd like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in the Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not. So I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
All right, so Mr. Alessi, I think if we're going to,
I am, and I'm going to move on, Your Honor.
So
okay, Mr. Alessi, hold on, we're going to do that for you.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could,
Okay.
please.
I wasn't finished with my
Go ahead, finish your answer. I'm
So
sorry.
slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did
The
you
answer is no.
engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
written.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting there while we do it inside. So tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here until, we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Fourth admonition, please be very careful with your social media use. We'll see you tomorrow morning.
Rise to the jury.
Why did he chuckle at that? Fucking weirdo.
Say it, yes.
Tomorrow's a half day. She said that last week. No, she told us last week that Thursday this week was a half day. I wouldn't be surprised if she gives him Friday off. He's like the epitome of Ipsy Dixit. I just saw on Twitter, there was somebody who says they have no dog in this fight. He sure won't stop fucking fighting with
Okay,
Alessi.
Mr. Alessi, it's your voir dire.
If I have a moment, Your Honor, to switch.
She didn't say why.
Your Honor,
Yes.
can I load up my slides?
Yeah, can you do that while you're sitting here answering questions? Yes.
Curious to see how much he argues with Alessi now that the jury's gone.
I'm going to start with Your Honor with regard to the true or false.
Okay. And we're on a very limited schedule here. Okay.
Okay, Your
I
Honor.
need a drink, Alessi. Hurry your shit up. My vodka's waiting for me at my sidebar.
Mr. Wilk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced it.
Sir, I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Thought he didn't read the CARS report.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report? Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint. Yes, it's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes.
Oh my God.
Your Honor, why do we?
Well,
I have limited. Go ahead.
so that particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report.
You did use it. That's how the defense has it in your fucking PowerPoint, you
We have a
idiots.
hard copy of Trooper
They didn't put it in there
Turn the
for
lights
you.
on, please.
She's like, obviously, this isn't going to go very quickly, and my drinks are going to get watered down, so it's time for me to go. We'll do this tomorrow.
May I approach, Your Honor?
Yes.
I'm going
Show
to.
Mr. Brennan.
Yes, Mr. Brennan, this is. May I approach you, witness? Excuse me, Dr. Welcher. You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to?
Lisa, can you show me the signature?
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Signature block right here.
Yes.
Trooper Paul, page 16.
I have that.
Yes.
Thank you.
You're welcome.
Now, what I want to do is to go to diagram 1. And if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different, none of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome. Do you know of any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not
Yes, it is. You asked me anything but the report. That image is not in
Oh
that
my
report.
God.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay.
What file?
Did Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second. Yes, it came in a file called cars dash trp.jopal.
Okay.
Oh,
So it
fucking
came,
A.
and that's the report of Trooper Paul, correct?
No, these are
What?
drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes,
that contains a bunch of things, including the report.
understood.
That image is not in his report.
Oh my
Can you
God.
read the file name again that you just read?
The folder name
Yes.
is cars-trp period Jopal.
Okay. And did you get the drone image from that file folder?
I did.
Okay, thank you.
You're welcome.
Now let's go on
Wow.
to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27.
This is all just so that he's able to question him on
Have you
Trooper Paul's
discussed
info.
with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I believe.
Okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the CARS report of Trooper Paul on your computer?
Think so? You remember the name of it?
I don't. We'll do it with the hard copy. Mr. Brennan, I'd like to show him this one. Thank you. So if I could approach, Your Honor?
Yep.
So you see what I'm pointing to right here, which is page 10 of Trooper Paul's CARS report. Do you see that?
I do. Is this the same report? Is it dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare this with the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's frozen.
Okay,
So that's just paper.
okay. So we have that report,
Mhm.
and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to
That's what I said.
your, continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Lessie. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see these photos?
I'm sorry.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Those are Trooper
Yes.
Paul's
What do
photos.
you recognize in terms of the person in it?
Oh. You want me to limit it to just these 3 photos?
Any photo that would be, this photo or any photo similar to it? But let's start with just these 3.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone is inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
He had said, and I can't say it verbatim what he said, but he had said that he did not use Trooper Paul's stuff when Alessi was questioning him on it. I don't remember it verbatim, though. I'd have to go back and listen again. But essentially, so then they go to the sidebar.
And go to slide, and I think I can do this fairly quickly.
Okay.
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the
One before that.
Yep, I think you're, yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one.
Oh,
Yes,
this is
that
somebody
one, and
else's
scroll
photo.
down
We
so
talked
you
about it
can
the other
see
day.
what's in green.
This is somebody
For
else's.
That depiction, that is from Dr. Scorty Bellows' autopsy report,
There you
page
go.
3, correct? Is that where you got that from?
It's from the report. Take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Just go straight right there. Yep, yep, I got it. Yep, thank you. If you can go to the very top line, it says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay, you are all set, Doctor.
Thank you, Ron.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep it under 2 minutes? Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scortabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scortabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just gonna
I have
decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scortabello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall the slide that you had has the final diagnoses of Dr. Scortabello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You
Correct.
considered that.
Correct.
Thank you. No
You're welcome.
questions, Your Honor. I
All right.
appreciate that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Lessie, how much longer are you going to be tomorrow?
If I could have a motion, Your Honor.
Yes.
I'm about halfway through, Your Honor. I think it will take up, looking for tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Oh, that's right.
Tell the witness to shut up and answer the
So
fucking
it may
questions.
be that
and
we
we'll
have
be
a
done.
20-minute break tomorrow and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case, and we've got to be able to proceed through to the question. He covered a lot on his direct and he probably.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
I'll give you my answer at that particular point.
Okay. All
Tell
right.
him to answer the questions
Thank you, Dr. Welcher.
and stop arguing about everything. And he'd be done and he could go home. He doesn't need to be so damn argumentative all the fucking time. Somebody needs to address that guy. So irritating. All right, well, I can't really stick around. Sleuthie, are you back yet or no? That was a long bus stop for you. I'm kind of driving, so I'm gonna have to wrap it up so that I can actually drive. So On that note, we'll see you guys tomorrow for half day, and then maybe for the second half of the day, especially if it is short. Maybe we could do some old Higgins, Brian Albert testimony. So we'll see how tomorrow kind of pans out. I don't have a ton of plans for tomorrow night, so we should be able to get through some of it, or maybe we'll just start a second stream and just do that. So we'll play it by ear and talk more about it mañana. So love you guys. Thank you guys for hanging out with us. As always, I know you have 1,000 other places you could spend your time, and you choose to spend your time here with us, and we love you for it. And in the words of Sleuthie Goosie, since she cannot say them, love you, bye.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going Do you dare to follow me down? Head into the unknown.